In view of the above reasons, we are of the view that exception 1 to section 300 is attracted to the facts of the case. Accordingly, the appellant is convicted under part 2 of section 304 IPAC and is sentenced to undergo rigorous imprisonment for a period of 7 years, of which fine imposed by the learned trial court. The appeal is partly allowed. The conviction under section 302 is converted to section 304 part 2 IPC. Applies. Then for your fees, we have written appropriate fees to be paid.
And he has already undergone 6 years of imprisonment.
The period already undergone by the appellant shall be set off from the period of imprisonment imposed on him. So a few months, I think.
Apply.
Please, Your Lordship. Your Lordship, I beg to mention item number 14, 15, and 17, Your Lordship.
Yes, madam. What about it?
My senior, due to some personal difficulty, he was unable to complete the case.
Lordship, this item 14 to 18 are connected matters arising out of the same judgment, Lordship. Okay.
Your consent has been taken, I think.
Lordship, yes.
Okay, right. Miss
I Kitza, Your Lordship.
R.
I Kitza.
I Kidzer. No, it's here. Its name is here. KEITZAR. Learned Counsel submits that her senior, Mr. M. Saranya, is having some personal difficulty and accordingly prays for adjournment. Full stop. Mr.
A. Banerjee. I am on behalf of N. Sorkar.
What do you want?
Item number 16. It's
Adjournment.
adjournment.
Mr. A.
Banerjee.
Banerjee appearing on behalf of Mr.
N. Sorkar.
N. Sarkar also prays for adjournment. Full stop.
My lord, I am appearing in item number 18, my lord.
Mr.
P. Prasad, my lord.
P.
P. Prasad. I have not been served. with
B.
the-
Prasad
P. Prasad.
appears for respondent number.
A petitioner
Now
appellant
appears for the appellant
in item number 18.
in Criminal Appeal 171/2019
I have not been served with a copy of the paper.
and submits that he has not been served with a copy of the paper book. Then you ask the registry. He is to. No, the registry is to supply him a copy of the paper book. Next para. Mr. R.K.D. Chaudhary, Deputy SDI, submits that an adjournment request had been made to him yesterday, and he has also signed the said application, said memo yesterday. Next para. In view of the above reasons, the matter is adjourned for
It will be after the Bihu vacation, Lordship.
the matter be listed after the Bihu vacation.
Obliged.
Jail appeal.
Yes. Amicus curiae will be appointed. It will be admitted.
Okay, right. And this is a jail appeal challenging the judgment dated 20/10/22. No, 31/10/22, by which the appellant has been convicted under section 302 IPC. Admit the appeal, call for the LCR, issue notice. Ms. B. Buyan, additional PP accepts notice on
I
behalf of
cannot,
the state.
Lordship, she will accept.
Ms.
Chakraborty.
M. Chakravarti accepts notice on behalf of the state. Leaves the matter after receipt of the LCR.
And amicus curiae will be appointed.
Okay, who do we appoint them like this?
S. S. Attorney.
Miss?
S. Attorney.
Give some other name for the time being, some new name. Mr.
M. Doctor.
Mr. M. Datta is appointed as the amicus curiae. This is the matter after receipt of the LCA. This is a jail appeal challenging the judgment dated 23/12/22, by which the appellant has been convicted under section 6 of the POCSO Act. Admit the appeal, call for the LCR. Miss so-and-so accept notice on behalf of the state. Then who do we appoint?
Bornali Chaudhary.
Miss Bornali Chaudhary is appointed as the amicus curiae in this case. This is the matter after receipt of the LCR. Next. This is a jail appeal challenging the judgment dated 4/1/2023, by which the appellant has been convicted under section 376(3) IPC, read with section 4 of the POCSO Act. Admit the appeal, call for the LCR. Miss so-and-so accept notice on behalf of the state. Mr. B. Prasad is appointed as the amicus curiae in the case. This is the matter after receipt of the LCR.
Is it Lordship? I challenge
Heard, what is your name, madam?
S. Chakravarti.
Heard Ms. S. Chakrabarti, learned counsel for the appellant, who submits that the judgment dated 29/1/22, by which the appellant has been convicted
Right, you can see.
under section 4(8),
Four.
under section
302 IPC, 376.
under section 302 IPC. No, they are
I
convicted
don't have papers in me. 376 AB IPC and 6 of POCSO.
have been convicted under section 376
AB,
AB,
AB IPC and
AB IPC, read with section 6 of the POCSO Act
yes.
and 302 IPC, by the court of the special judge bracket POCSO, Kokraja, in special case number 1/2020, should be set aside. Admit the appeal, call for the LCR. Issue notice to the respondents. Miss so-and-so accept notice on behalf of the respondent number 1. Appellant to take steps for service of notice upon the respondent number 2 by registered post with AD within 3 days. This is the matter after receipt of the LCR.
This is a jail.
Your name is
D. Borpujai.
Miss D. Purpujari, learned counsel for the appellant. Praise that the impugned judgment and order dated 26/5/2022 and 30/5/2022 passed by the Court of the Learned Sessions Judge cum Special Judge Morigaon in NDNPS case number 3/2020, convicting the appellant under section 22C, read with section 29 of the NDNPS Act, should be set aside. Admit the appeal, call for the LCR. Mission to accept notice on behalf of the state. This is the matter after receipt of the LC. Yes, so everything is in order, ready?
I have not received paper book, madam.
You know,
We have- we have-
you have received,
Yes.
okay, right. Mr. M. Datta, learned amicus curiae submits that he has not received a copy of the paper book from a while. Ms. B. Boyan, additional PP submits that she has received a copy of the same. Registry to furnish a copy of the paper book to Mr. M. Datta, learned amicus curiae.
And list the matter for
And
hearing.
this is the matter for hearing in usual course.
Obliged, Your Worship.
You have received?
No, Lord.
You not
Yeah,
received?
I
You have
have,
received.
yes.
Miss
Barnali,
B. Chaudhary,
yes, sir.
learned amicus curiae. Same order, huh?
For hearing.
For hearing. Yeah, you have received,
Yes, Your Worship. Paper book has been received.
and so, madam, you
I have
got,
received.
so for listening for hearing in
Yes,
usual
ma'am.
course. Okay, right. Miss S. Khatania, learned amicus curiae, and Miss B. Buyan, additional PP submit that paper book has been received by them. Accordingly, the registry to list the same for hearing in usual course.
May I please, Your Worship? At this I am for bail manage. Here, the appellant is convicted for 20 years ballot under section chair 376 AB IPC. Initially, the case was registered.
Not under POXO.
Yes, madam.
Live streaming.
Huh?
Live streaming. Stop.
Next statement, she said, Lordship, she has not seen who has taken the disease, what happened to him afterwards. Nothing is seen by her, Lordship. Except that there is no material to connect the appellants with the crime, Lordship. Only this much. And in my humble submission, is that even if we assume that last seen together is there for this bail application, if we assume that also, then also it is not sufficient to convict the appellants in absence of any other circumstance, Lordship. This is already held by our High Court, Lordship. Just relying on Honorable Apex Court judgments from paragraph 24 onwards, Lordship, may I see of the judgment. Paragraph 24 onwards. 24, 25, 26, and 27.
Paragraph?
Paragraph 24. 24, 25, 26, 27. May I read?
Yes.
In case of Leelaram versus State of Haryana, reported in sense of the Honorable Supreme Court has held that circumstance of last seen together is a weak kind of evidence. In case of Kanhaiya Lal, reported in sense of the Apex Court has held that the circumstance of last seen together does not by itself lead to the inference that the accused had committed the crime. There must be something more establishing the connectivity between the accused and the crime. Similar view has been expressed in case of Ashok versus State of Maharashtra, reported in Senso, whereby the Apex Court has observed that in a case of last seen together, the prosecution would be relieved from proving the exact happenings of the incident, as it is the accused who would have special knowledge of the incident. However, the burden of proving the charge by adducing sufficient evidence pointing towards the guilt of the accused would always be on the prosecution. It has further been held that last seen together itself is not a conclusive proof, but along with other circumstances surrounding the incident, the same may lead to presumption of guilt, more so if the accused persons fail to offer a reasonable explanation discharging the burden under section 106 of the Evidence Act. What flows from the aforesaid decision of the Honorable Supreme Court is that it would be wholly unsafe to base the conviction of the accused only on the circumstance of last seen together, and the prosecution must adduce evidence to prove the other links in the chain of circumstances so as to prove the guilt of the accused. It is only when such burden is discharged by the prosecution that the failure on the part of the accused to offer reasonable explanation based on the circumstance of last seen together that would amount to an additional link in the chain of circumstance which could go against the accused. So here nothing except that last seen together if we accept for the type road. And regarding the place of occurrence is also there is discrepancy.
But that would depend on the facts of each case.
Yeah.
It cannot be as a general rule.
Yes,
It depends on, you see, if he was called out and he was started, and then you start hearing shouting straight away. And what more do you want? You cannot have an eyewitness on all crimes.
Yes, that is true. But for their logic to convict the appellant, there has to be some material to show that these are the persons involved. If your lordship kindly turn to evidence of PW7, PW5, lordship. He says a crowd has attacked him and thereafter he was killed. Page 22 of my compilation, lordship. Page 22. Last three lines your lordship will find. The next morning, Secretary of the Tea State, Sancho Bapuria, informed me that a crowd had killed Lal Bauri and asked me to come. So it is said crowd has killed, and this witness is not declared hostile, and unless he is declared hostile, his evidence is binding on prosecution lordship. And in the judgment also, your lordship will not find a clear finding regarding 34. What was the common object of those two persons? That is not there.
This one is after this one came to know about it in the morning only.
Yes, that is the case of the prosecution. Because crowd came, because it was suspected that this was involved in witchcraft. The crowd came. Who are those crowd from? That is not clear from the evidence.
So the conviction is based on PW5's evidence.
PW3, what you will find, PW3. Page 14. Only chief part was considered, not the cross-examination part. Because in cross-examination, she herself said that I have no knowledge who have tied my husband and beaten him since I was at home. In fourth line from cross court, you will find. That part was not considered. If she was at home, she cannot see what happened there. And if your lordship sees the evidence of the IO, he also did not say that where the incident took place. In cross part, a specific question was put to him. Page 25, your lordship will find cross second paragraph. I do not know from where the dead body was recovered, as it was recovered by ASI Sharif Hussain. From where it was recovered, it is also not clear.
How many witnesses are there?
7 witnesses. 6 witnesses. Just,
This
one
PW2, you do not have a translation.
Yes, I have given the translation also. PW2. He was brother of the deceased and he was declared hostile. And during trial, they were on bail. That is also a relevant factor. Also, just I am relying on a judgment of Honorable Apex Court. Paragraph 18 of the judgment document. Paragraph 18.
Where is the evidence of PW7?
PW7. PW7 is not there. Up to PW6. Total 6 witnesses are there.
Only 6
Only
witnesses.
6 witnesses. That one more judgment I have given, Lordship, regarding 389, page paragraph 18, Lordship may kindly see that here High Court has granted bail thereafter against that they went to Supreme Court and Honorable Apex Court said, we are of the opinion that paragraph 18, Lordship, I am reading. We are of the opinion that High Court has rightly applied its discretionary power under section 389 proviso to enlarge the respondents on bail. Firstly, both the criminal appeal and revision filed by both parties are pending before the High Court, which means that conviction of the respondents are not confirmed by the appellate court. Secondly, it is an admitted fact that the respondents had been granted bail earlier and they did not misuse the liberty. They were on bail during trial and they have not misused the liberty.
So he was on bail during trial.
Yes, during trial they were on bail. That your lordship will find in appeal memo, paragraph 39, page 39. Four persons faced trial, out of them two were acquitted, these two were convicted. And third column, your lordship will find date of release on bail, date of arrest and date of release on bail.
Yes, madam.
Lordship is aware of regarding the witch hunting, Lordship. It's a serious menace in the society, Your Lordship. It's a clear case of witch hunting. The motive is that, Your Lordship, that this accused person's daughter died on that day, Your Lordship. And on the belief that this person was engaged in witch hunting, he was taken from his home, my lord. And this is not in dispute that he was tied in the residence of the accused person and
Okay.
he was beaten up.
In
Lordship
in the
may-
in the residence of the accused
Yes.
person, in the
Ibu
residence of
Tanti.
this,
PW3's evidence in Lordship, can you see? The informant is my son, at page 14 of the compilation given by Learned Friend. The accused persons are our neighbors. 3 years ago, one day, the accused Maheshwarya had come to our house and took my husband Lal Bari to Tibu Tanti house. My husband was beaten. Though I went to see, I was obstructed. Bapuria obstructed me from going to see my husband because the accused person may beat me. From about 12 a.m., my husband was beaten. My husband was tied in Tibu Tanti house and was beaten. Later, the police recovered my husband's dead body from so and so. My husband was beaten, suspecting him to be a Daini witch. Tibu Tanti daughter Dipanjali had died before the incident. So, motive part, Your Lordship, since his daughter died, so as a retaliation, he was killed, Your Lordship, he was beaten up. At this stage, may I pray, Your Lordship, may not grant it.
Lordship, may kindly see the cross part, third line, Lordship. Cross third line
Hmm.
of the same page.
Hmm.
I have no knowledge who had tied my husband and beaten him since I was at home. So
But
this
it's
is
an admitted fact, he was in the residence of the accused person.
So
where
therefore-
was, huh?
Therefore, she was not treated as an eyewitness by the learned trial court, Lordship. That was rightly, in my humble understanding, rightly rejected her.
But this
Evidence.
case based on circumstantial evidence, Your Lordship. He was last seen, Lordship, he was at the residence of the accused person and he was beaten up. She went there, but she was not allowed to go inside. Lordship, she was obstructed, my lord.
Because of this cross, Lordship, she was not treated as an eyewitness. So if once her evidence is rejected, Lordship, that then from the evidence it is clear that she was at home.
since I was at home.
And the Lordship will find page 25, paragraph 42 of my appeal memo, that it is observation of the learned trial court that evidence on record would reveal that there is no eyewitness to the alleged occurrence.
Page 42.
Yes, page 25, paragraph 42. Page 25 of appeal memo. Page 25, paragraph 42. And in page 26, fourth line, your Lordship will find PW3 has not seen who has beaten her husband.
But your Lordship, may kindly see page, para 44.
Yeah.
The evidence of PW3 was taken to be arrest as to witness just before the occurrence. So it's admissible in evidence, your Lordship. Para 44, page 26. Last few lines. The information by PW3 given immediately to her son PW1 when Lal Bari was taken away by Mahesh Uriya just prior to the actual occurrence, who in turn deposed to during the evidence as PW relevant fact and admissible in evidence.
So for that, already I have submitted the judgment of our High Court where honorable
Section
affairs
6 of
court judgments
evidence
are
of my lord.
discussed. Where it is said that even if we assume that last seen together is there, that itself is not sufficient to convict a person.
We have to see the entire judgment.
I know.
It depends on the facts of each case.
No,
Okay,
except
you see, a judgment is only a decision for the facts of that particular case. We don't know
No.
what are the facts of that particular case.
yes, that is what I was submitting. Lordship. There is nothing on record except that last seen together theory.
Just a minute.
And 313 statement is also not before us, your Lordship, what plea they have taken
Yeah, that is records.
as to the occurrence. So your Lordship may ask the registrar to prepare a paper book since LCR has arrived, my lord.
If Lordship ultimately if Lordship find that they are acquitted, Lordship, they will be acquitted, then there is no
You see, one thing is that he was taken away
by whom?
by these
That-
two
that-
persons. This is
No,
not doubt.
not by 2%, Lordship. Lordship, I am taking your Lordship to again PW3, Lordship, may see. Not by 2%. That is also disputed. That is what I was placing. Lordship, may kindly see. PW3 I am reading.
Yeah.
3 years ago, one day, accused Mahesh Uriya had come to our house and took my husband. So this is against Mahesh Uriya, not the two applicants.
Okay. So this
Here, Lordship, two applicants are there. Tanti and Mahesh Uriya. Two applicants.
And it was in a residence.
okay.
of
So
Tipu Tanti.
Mahesh Arya is there. Mahesh Arya is he's the respondent. He's the applicant number 2.
Applicant number 2. And
Yeah.
if your Lordship see page 25,
And taken to Tipu
Tipu
Tanti's
Tanti's house.
house.
Whole
So what
night
is-
he was there.
no,
Now,
Lordship,
She
what
was
is the
obstructed.
what is the police evidence?
that is I am placing page 25, Lordship, may kindly see. Page 25.
Yeah.
Second paragraph of cross, Lordship. I do not know from where the dead body was recovered, as it was recovered by ASI Sharif Hussain. So especially question was put by the defense, because no incident took place in the house of the appellant Tipu Tanti, Lordship. Therefore, defense took that courage to ask him directly, Lordship, where incident happened and where dead body was recovered.
But what is his finding on the case? Where was he beaten up? Nothing is stated there.
Nothing is clear.
Dead body was thrown out in the river, my lord.
Where is the earlier?
Who thrown the dead body to river, that is also not in the evidence, because that also has to be brought by the prosecution, Lordship.
Sharif, ASI Sharif Hussain,
Was he?
was
Yes.
he examined as a witness?
No, he was not examined.
So he must be knowing.
Yes,
Let us see the case diary.
it is in the
In the case diary, let us see what is there. Okay, diary will all assume.
May I see?
It will, huh?
Even if we assume, Lordship, that he was taken to the house of the appellant, thereafter he was beaten, but who has thrown the dead body to the river, Lordship, that part is not there in the evidence.
He is beaten up. Before his body was thrown, he was dead.
No, in circumstantial case, Lordship, that chain of event has to be proved beyond reasonable doubt. Here, even if we assume that he was
What is the
taken for
doctor's,
assaulting,
what is the doctor's evidence?
doctor's evidence is, you will find PW4, page 18.
This opinion is due to coma as a result of head injury.
Yes, but who has caused that, that is not there.
So there is not
Because
the,
I am facing child under section 302, so possession has to prove that I have caused that injury. Either by direct evidence or by circumstantial evidence. And from the evidence of PW3, you have already seen that she said she was at her home. She has not seen the incident. And except her, no one there to investigate the appeal.
He was thrown out. They took the help of NDRF and SDRF to
Huh?
recover. Body was thrown out as per the statement of the villagers. And your lordship, then the dead body was recovered with the help of NDRF and SDRF. River
no, I'm
police.
not on that.
Yes,
What is the investigation
yes.
done by the Sharif? Uh, what does he say that the deceased was taken to this auntie's house or not?
Yes, yes. Usi Mohoda so and so, it's in Assamese, my lord. From the local inhabitants, he could come to know, since Dipanjali, the daughter of the accused person, was dead last night, and she was blood vomiting, my lord. And there are statements given by other witnesses also in the case diary also. In the early morning, the dead body was thrown out. As per the statement of the witnesses. this IO, he has given the statement, and his statement, his report is there, your lordship, in the case diary, that he was tied in the residence of this accused person only.
So what is your stand that you did not call out this persons from the house
No,
in 313?
no, no.
Never
Not
seen
denied
it,
by
313.
313 is denied by them
He denied everything. Complete denial.
completely. 313, in my humble understanding, lordship, will come only if they prove some material lordship. That I have already placed before your lordship, paragraph 26 of the judgment.
No, but then there are decisions also that if you do not offer proper explanation, then
That is an additional link subject to correction lordship, but they have to prove their case first, that they have to connect me with the crime lordship. Some primarily there has to be some material acts. Only that last seen together, that will not do. Just I'm relying on another judgment of Honorable Apex Court lordship. This just fact of the case is there. Husband and wife were sleeping in the house in a
That
same
is
room.
different, that is a
Just
Timuk
I'm
matter.
placing, husband and wife were found in the same room. lordship. Husband was found dead with homicidal injuries. lordship. His neck was cut. Thereafter, wife did not explain during trial anything regarding the death of the husband. Our High Court convicted her. Thereafter, went to Supreme Court. Supreme Court said that explanation will come once there is something to connect with the connect the accused with the crime. Then explanation will come. Here, my case is better than that case. lord.
We are
In my
total
understanding,
denial
lordship.
in 313.
She was found in the same room.
both of them, Kanti also,
Yes,
Mahesh also.
Mahesh also.
Any explanation where they
No,
were?
nothing. It is true, I don't know. Nothing, my lord. I do not know, I do not know.
Okay, right. Heard
Paragraph
Mr.
9, lordship, may I kindly see this judgment?
Huh?
Paragraph 9 of the judgment on non-explanation. The essentials of circumstantial evidence stand well established by precedents, and we do not consider it necessary to reiterate the same and burden on the order unnecessary. Suffice it to observe that in a case of circumstantial evidence, the prosecution is required to establish the continuity in the link of chain of circumstance. Here, lordship, he was taken, thereafter he was beaten, he was thrown in river, that chain is broken, lordship. So as to lead to the only and inescapable conclusion that the accused, being the assailant, inconsistent or incompatible with the possibility of any other hypothesis compatible with the innocence of the accused. Mere invocation of the last seen theory, sense facts and evidence in a case will not suffice to shift the onus upon the accused under section 106 of the Evidence Act unless the prosecution first establishes a prima facie case. This is clearly covers my case. If the links in the chain of circumstance itself are not complete and the prosecution is unable to establish a prima facie case, leaving open the possibility that the occurrence may have taken place in some other manner, the onus will not shift to the accused, and the burden of doubt and the benefit of doubt will have to be given. So that is my case, lordship.
Lordship, in the instant case, the prosecution could prove, my lord. He
That is
was
only the last
brought from
incident.
his residence. He was tied in the residence of the accused person.
Tied in the residence of the.
Yes, accused
where?
person, yes, Tiputandi's house. He
Who
was
was-
beaten up.
Who has said that?
PW3,
PWC in cross said that she was at home.
And the motive part, my lord, since the accused person's daughter was dead, they have the lordship accusation is
There
that
is
because
slight
of
problem, madam. You see, what you're saying is very logical, no doubt. But the problem is that the evidence does not support.
evidence of PW3.
Evidence of PWD,
Yes, I-
what about the cross?
Yes, your lordship.
What about the cross? Prima facie, we are saying, we are not making a final
Right, right.
decision. PW3,
My husband was beaten. Though I went to see, I was obstructed. Bapur obstructed me from going to see because the accused person may beat me. From about 12 a.m., my husband was beaten. My husband was tied in Kibutati house and was beaten. Later, the police recovered my husband's dead body from so and so. My husband was beaten, suspecting him to be a Daini. Kibutanti daughter Dipanjali had died before the incident. I was at home and had not come out of the house prior to the incident. My husband had a good relationship with, because it was a flood, your lordship, and these accused happened to be the resident of same area. They knew each other. She went there,
but you see, when she says, I was at the home, I had not come out of the house. So where's the question of obstruction?
may I see the vernacular portion?
I have given the vernacular.
মই ঘৰতে আছিলো, ঘৰৰ বাহিৰ ওলোৱা নাই, whether on the same day. সেইদিনা, that portion is missing. On the relevant date, I was at home, that is missing here. The lordship other day observed, my lord, this innocent villagers, my lord. মই ঘৰতে আছিলো, ঘৰৰ বাহিৰ ওলোৱা নাই. Whether she was talking about that on the relevant day or some other day, my lord. It's not specific.
And she clearly says that who tied her husband, she did not see. In Assamese also. Lord. কোনে মোৰ স্বামীক বান্ধি থৈছিল আৰু
The problem is that you have taken her out away also. That is another thing.
that I will satisfy your lordship at the time of hearing, but that itself is not sufficient to convict that. That is my submission. If ultimately your lordship acquiesces that his incarnation in jail, that will yeah.
We might acquit an innocent person or a guilty person. Then what happens?
That your lordship will find the evidence. But prima facie, I have shown your lordship.
She has
Because she
reiterated.
says clearly who had stopped her from going. Bapu Oria. Who is Bapu Oria?
He is not before your lordship. And even he was not an accused, if I am not wrong. He was not an accused.
Since the LCR has arrived, may I pray the paper book be prepared, short day be given if he has a case deal, the acquittal, in the final hearing.
In that case, lordship, section 389 will be of no use. Lordship. If in every case, lordship, paper is directed to prepare the paper book and fix for hearing.
Not in every case,
Because
when
this
there
is
are
the case
materials.
where I have placed for your lordship that even if I assume that everything which the prosecution has said is correct for this bail application, that only last seen together is there. And that is not sufficient to convict an accused.
Not only last
Even
in
if
theory,
there is any
race
material,
testing
my learned
evidence of
friend is,
PW3.
Landed friend can place.
One of the circumstances that he was beaten and he was tied inside. Motive part, it comes in, my lord, not only last in theory.
Just I'm making myself clear, Lordship. PW3 says she was taken and thereafter she was at home. She has not seen who has tied up.
No,
who has
but then
beaten,
you
Lordship.
see, if he has been taken from the house. What do, it doesn't have to be
Regarding
taken from
that,
the
Lordship,
street.
where the incident happened, how, where the dead body was found, nothing on material, Lordship, is there, Lordship.
Dead body is found in the river.
She says, Lordship, he was taken to my house, Lordship.
There.
Thereafter, how he went there, who has seen, Lordship, nothing on record, Lordship. Because they have to connect me with the crime, Lordship. Only last sentence theory will not do. And if your Lordship see, then again I am reading that cross part, Lordship. I have no knowledge who have tied my husband. So who was the person who has tied and beaten him? Who has beaten him? Nothing on record, Lordship.
But the very fact that you have taken him and now you're denying taking him also. What does that imply?
Yes, that
When
similar
you
that
take somebody out from the house, he's found dead, and then you deny everything. What does that imply? That you're hiding something.
no, they have to prove, they have to place some material to connect me with the crime. That is Rina Hazarika's case, what I have placed with your Lordship. That even if last scene is there, that non-explanation will come only if they, just I'm reading that line again, Lordship. Probably I'm not able to. Mere invocation of last scene theory, sense facts and evidence in a case will not suffice to shift the onus of the upon the accused under section 106 of the Evidence Act unless the prosecution first establishes a prima facie case. So that is
So,
my
your
case.
lordship, may I distinguish my Lorina Hazarika judgment and this honorable, this present matter? Only on last in theory, a person cannot be convicted, but there in the instances, there are other materials to substantiate. Motive part, he was there, although last in theory, my lordship fear negates that part. Other factors comes into play, my lord. He was beaten up, she went there, she was obstructed.
Just fact of the Rina case, she will find paragraph. So just I'm reading the fact of the Rina Hazarika case. The deceased resided along with the appellant and his minor daughter CW1, so resided about 9 years in a tenanted premises belonging to PW1 Manoj Kumar Deka, PW2 Dipen Deka, PW3 Brigu Moni Deka, who are brothers. The appellant is stated to have assaulted the deceased in the intervening night. So there also motive was there. PW1 and 2 and 3 are stated to have heard noises and going there found the deceased with the head injury attributed to a fall, but that the deceased was otherwise all right. They were unable to take him to the hospital because of rains and unavailability of an ambulance.
Okay, right. Third, Mr.
Yeah.
Ahmed, counsel for the applicant appellate. Also heard Ms. B. Buyan, additional people. This application under section 389 CRPC is for suspending the sentence imposed in connection with the judgment dated 5/11/2020 passed by the Court of the Learned Additional Sessions Judge, Jorhat, in connection with sections case number 241/2006, by which the appellant has been convicted under section, appellants have been convicted under section 302/34 IPC. And they have been sentenced to undergo a rigorous imprisonment for life and to pay a fine of rupees 5,000. In default,
Pay a fine of rupees 5,000.
in default,
Fine of rupees 5,000. Page 36, your lordship will find.
fine of rupees. If you don't pay 5,000, then what happens?
Simple imprisonment of 6 months.
Simple imprisonment for 6 months. The learned counsel for the applicants submits that the entire the submits that the conviction of the appellants has been made on the basis of circumstantial evidence and in terms of the bench judgment of this court in criminal appeal bracket J 103/2020, Dhiren Tanti, Sonitpur, Assam versus the state of Assam and another, it would be this court has the division bench has held that it would be wholly unsafe to base the conviction of an accused only on the circumstance of inverted commas last seen together, and the prosecution must adduce evidence to prove the other links in the chain of circumstances as to prove the guilt of the accused. The learned counsel for the applicant submits that in the present case, the only evidence against the appellants is the evidence of PW3, who has stated that the applicants, not applicants had come to their house and taken away her deceased husband to the house of the applicant number one. Now, what did you say? Applicant number two had the applicant number. Just a minute. Who is this applicant?
Applicant number 2 has taken,
Applicant number one, applicant number two has taken the deceased husband of the deceased husband to the house of applicant number one. He submits that though PW3 has stated that she was obstructed while attempting to go and see her husband who was being beaten up, the cross-examination of PW3 is to the effect that she had not gone out of her house and had no knowledge as to who had tied up her husband and beaten him. She also submits that the evidence of the witnesses does not give any indication that the applicants had beaten up the deceased. To stop further, PW5 has stated that Bapu Uria informed him that a crowd from the garden was physically assaulting the deceased. So this Bapu Uria is the same person who had blocked PW3. So Bapu Uria was there.
yes, 10%.
PW5, no, full stop. The learned counsel thus submits that as there is no there is no evidence to show that the appellants had beaten up the deceased or had tied him up in the house of the applicant number one. The conviction of the appellant was illegal. As the last seen together, inverted commas, huh? Case, the last seen together principle could not be conclusive proof that the applicants had killed the deceased. That's all. Miss,
That Rina Hazarika's case.
Huh?
Rina Hazarika's case, that explanation will come only if the prosecution prima facie proves the case. Paragraph 9 of the Rina Hazarika.
he also submits that in the case of Reena Hazarika versus State of Assam, reported in 2019, 13 SCC 289, the apex court has held that in the case of circumstantial evidence, the prosecution is required to establish the continuity in the chain, in the links of the chain of circumstances, so as to lead to the only inescapable conclusion of the accused being the assailant, inconsistent or incompatible with the possibility of any other hypothesis compatible with the innocence of the accused. Full stop. Mere invocation of the last seen theory, sans the facts and evidence in a case, will not suffice to shift the onus upon the accused under section 106 of the Evidence Act 1872, unless the prosecution first establishes a prima facie case. He accordingly submits that as there is nothing to link the chain of circumstances in the present case. The sentence imposed upon the appellant should be suspended and the appellant should be allowed to go on bail. First up, next para. Ms. B. Bhuyan, the learned additional PP, on the other hand, submit that the evidence of PW3 read with the evidence of PW5 clearly goes to show that the appellants were involved in the killing of the deceased. He submits that the appellant was taken out from the house. No, that the deceased was taken out from his house by the applicant number 2 and taken to the house of applicant number 1, where he was tied up and beaten to death. Thereafter, his body was thrown in the river, which was fished out the next morning.
She was obstructed.
Huh?
She was obstructed.
She submits that The evidence of PW number 3 clearly shows that she was obstructed from going to the house of house of applicant number 1 by Bapu Horia, who had also told PW5 that the appellant was physically being assaulted by a crowd from the garden. He also submits that the applicants have failed to offer a reasonable explanation in the case of the last seen together circumstance between last seen circumstance, and as such, there was no infirmity with the finding of the learned trial court
The motive part, my lord.
that
Motive part.
finding of the learned trial court in convicting the applicants. She also submits that the deceased had been killed on being labeled a witch doctor.
Witchcraft.
We
He was
are,
practicing
on being alleged to have committed witchcraft, which caused the death of the daughter of the applicant number 1. The learned additional PP submits that the decision cited by the learned counsel for the applicant is not applicable to the facts of this case, and accordingly, the application should be dismissed. Full stop. We have heard the learned counsels for the parties. Full stop. PW3 has stated that the applicant number 1 had come to her house and taken away her husband to the house of the applicant number 1. Applicant number 2 had come, and number 1. Though she went to see her husband, she was obstructed by Bapu Oria. On the ground that the appellants may beat her. Thereafter, her husband was beaten from 12 a.m. 12 a.m. means 12 midnight or 12 noon.
My lord.
12 noon, 12 a.m. This is
12 a.m. is midnight.
noon, no, midnight.
AM is midnight.
AM is midnight.
Yes.
AM starts from 0.001.
Yes.
Doesn't start from 12 a.m. There's actually 12 midnight, 12 noon.
Yes.
So actually AM should be till 12 a.m. I think. It'll start from 1. You see, 1 a.m. is night, 2, 3 a.m., 4 a.m., 5, 10 a.m., 11 a.m., 12 a.m. it should be.
Yes.
You see, it should be 12 a.m. You cannot have 1 to 11 as a.m. and 12 as p.m.
AM.
You cannot have. It has to be continuous.
Yes.
So this 12 a.m. is morning or night? What do they mean?
Night, my lord.
At night.
Night. So it's a 12 midnight. So what do we think?
Thereafter, her husband was beaten from 12 midnight.
From 12 midnight. After being tied in the house of the applicant number 1. The police thereafter recovered the dead body of the deceased from Tapodanga River. She also states that her husband was beaten up on being suspected to be a witch. In a cross-examination, the applicant No, the PW number 3 has stated that she had no knowledge who had tied up her husband and who had beaten him since she was at home. She also stated that her husband had good relationship, had good relations with the applicants prior to the incident. She also states that she does not know how many people had gathered in the night. Full stop. Next paragraph. The evidence of PW 5 who is the VDP secretary of Babariti Estate, BAHBARI, huh? BAHBARI Estate, is to the effect that he came to know about the incident on the morning of which date? On the morning of 13/7/2016. Is it 13/7? No, he came to know about the incident the next morning. Just say the next morning. That a crowd had killed the deceased. No, what have I said?
The evidence of PW5, who is the VDP secretary of so-and-so T estate, is to the effect that he came to know about the incident on the
It's
next
to the
morning.
effect that on a day prior to the incident, he had visited the house of the applicant, number 1, to inquire about the health of his sister who was suffering from tuberculosis. Upon reaching the said house, along with the pharmacist of Barbary Tea Estate, he declared her dead. He declared the sister of the applicant number 1 as dead. The next morning, the secretary of Tea Estate Majdur Sangha, Bapu Uria, informed him that a crowd had killed the deceased and asked him to come to the place of occurrence. However, considering the seriousness of the incident, and instead of visiting the place of occurrence, PW5 called the Polybor police station and informed them about the incident. In his first examination, PW5 states that Bapu Uria informed him that the deceased was assaulted by a crowd from the garden. He also states that he did not know if the deceased was tied up during the night. He also states that he also states that Bapu Uria did not tell him that the accused persons were involved in the assault and killing of the deceased. Okay, just right. Heard so. Uh, Hearing concluded. Order reserved. Then in the main case, you write LCR has arrived. As LCR has arrived, a registry to prepare the paperwork. This is the matter after preparation of paperwork in the main case. Okay. 1 minute. Hey, Amit. And learning that my student and Ms. B. Buyan, additional CP are present. As LCR has arrived, registry to prepare the paperwork. This is the matter after preparation of paperwork.
Alright. A copy of paperwork was furnished to parties. That direction.
They will furnish.
Alright.
This matter, Ms. K. Goswami, senior advocate, has been appointed to amicus. LCR is the scene for law.
So paperwork has to be prepared.
Yes.
Okay. And notice issued to respondent number 2 only on 27. So not even 1 month has passed. Okay, right.
Service report be awaited.
Huh? Yes, I
In
will.
the meantime.
Okay, right. As LCR has arrived, registry to prepare the paperwork. Full stop. It is noticed that notice was issued to the respondent number 2 on 27/2/23. Full stop. And no service report. No, as no service report has been made, comma. Await service report. List the matter after preparation of paperwork.
Thank you, Your Lordship. In this case, Lordship, LCR has not yet received.
So it's not required. We can have the, what about the
IA is for
389?
the,
Yes,
Lordship, IA is for the bail application of the.
yes.
accused, Lordship.
We'll hear this.
Lordship.
Acha, one thing.
They have filed. a-
One thing in the main appeal you just write. Miss R. Chowdhury
Lordship.
and Miss B. Bhuyan, additional PP are present. As LCR has not arrived, registry to send a reminder for the same. Then you say, this is the matter after 4 weeks. Then in the IA,
After receipt of LCR.
supposing it doesn't come for 20 years,
Lordship.
just for that, just in case. They might take it too seriously and wait for 1-2 years for it to come.
Lordship. Lordship is correct.
Okay, now in the IA, let us see.
Lordship, in this case, he was
Live
convicted.
streaming is stopped.
Huh?
Live streaming is stopped.
My lord. Bill submission is around 4 p.m. on 16/9/2016. I went to Tulsi Jora Bazaar from my home. When I returned home at 8:30 p.m., I learned that around 4:30 p.m. my grandson, that is accused Hafizur Rahman, had come to my house along with accused number 2, that is Zahida Begum. and her husband Akhtar Hussain, and taking the advantage of my absence at home, Hafizur Rahman and Jaheda Begum in a body had killed Akhtar Hussain by strangulating him with a rope on the bedside inside my house at about 6 p.m. I therefore pray you to take necessary steps upon investigating the matter and oblige.
Hmm.
Lordship. Lordship, this is a case that murder was there.
Hmm.
But in this case, Lordship, though I go along with the Hafizur, the co-accused, representing my learned brother, my Lordship, but I have no role in this case, Lordship. Because
You are Jahida Begum.
Jaheda,
Your
Jaheda,
husband was the one who died,
who died, my lord,
correct?
my lord.
And now you are married to this
Hafizur,
Hafizur Rahman.
Lordship, co-accused.
You took your husband, you and your husband, and this Hafizur Rahman went to the house of your grandfather, correct?
Lordship.
And then you both left. You both left your husband,
In
and
the
you went away
Lordship, with a promise to return
with a
back,
promise. What promise? You are a husband and wife. What promise? He was drunk or he was
Lordship.
ill. According to you, he was ill.
Lordship,
He was ill.
Lordship.
If he was ill, you left him there
Because
in some
Lordship,
other
I have a
person's house.
baby in my lap, my lord,
He had a baby in your lap.
my lord.
And where did you go with the baby?
Along with my husband, with Hafizur Rahman is our friend, my
No,
lord.
no, but then you left your husband in Hafizur Rahman's grandfather's house.
Because Hafizur Rahman promised me that he will bring my husband back because he is ill, so he unable to walk, my lord, as he
Where
consumed.
did you all go before that? Any idea where did you all go?
To whom, my lord?
Huh? Tour,
Mine.
walking tour while he was ill. What kind of illness did he have?
He consumed liquor, my lord, not alcohol. My lord.
Consume liquor.
Liquor, consumed liquor, my lord.
What time did you reach this Hafizur Rahman's grandfather's house?
It is about 4, my lord,
Around 4. Around 4 o'clock.
my lord,
4 p.m.
my lord.
And when did you leave the house?
After some time, I left the house.
How long after some time?
Approximately 1 hour to
After 1 hour. You left the house
my lord.
with the promise that you would come back, or with the promise that Hafizur Rahman would bring your husband back?
Hafizur Rahman bring my husband back.
And where did you go?
To whom, my lord?
You went home.
No.
And while you were there in the house with Hafizur Rahman, anybody was there in the house
My
along
lord,
with the husband?
my lord, my lord.
Who was there?
So, Lordship, on oath, Lordship, your Lordship may kindly go page 18, Lordship, PWD 6,
Hmm.
PW 6. You see herself, my lord, on oath, Lordship, page 18, Lordship.
Yes.
My Lordship. I know the informant, I know the accused person. About 5 years ago, at about 4 p.m., I was in my house, and at the time, the wife of the informant, namely Mulukjan Bibi, was also present at my house. Thereafter, Mulukjan Bibi went to her house. The house of Mulukjan Bibi is situated about 50 meters from my house. After about 1 hour, I went to the house of Mulukjan Bibi, and I saw that the accused Hafizur Rahman was sitting in a chair, and another person was lying on the bed at the corner of the said bed. The accused Zaheda was sitting. Thereafter, I asked SMT Zaheda as to what had happened, and then the accused SMT Zaheda told that the person lying on the bed is her husband, and her husband became ill as such. He was lying on the bed. At the time, the person who was lying on the bed spoke and asked the accused person as to where had they brought him, to which the accused person asked him to keep lying down, and thereafter I turned back. My lord, he was alive, my lord.
But when you left him, he was dead. That time he was alive, but after you left him, he was found dead. Correct.
Lordship. That is correct, Lord.
There were ligature marks on the neck.
Lordship, Lordship. But Lordship, doubt is there, my Lord.
And when did you marry this co-accused? When did you marry Hafizur Rahman?
After 2 years.
After 2 years. Okay, now, okay, let us go to one by one now. Let's go to PW1. So you have been convicted under 302.
Must, Lordship. Imprisonment for life, Lordship.
Let us go to PW1.
I am the informant of this case. I know the accused Hafizur Rahman and Jaheda Begum. I did not know Akhtar Hussain about 3 years ago. One morning, I went for daily wage work. I worked up to 5 p.m. and thereafter I went nearby market. From market, I returned to my house at about 7 p.m. When I arrived in my house, then I saw one person lying on the bed inside of my house. Thereafter, I asked my wife, who is the person? Then my wife replied, my grandson Hafizur Rahman came to our house along with one woman and another man. The man was the husband of the woman. Thereafter, by keeping them in my house, she went to the field for taking goat. When she returned to home,
For taking goat means what?
goat
For taking goat where? Taking goat where? For a
from the
walk?
field, my lord, from the field, my lord,
Huh? From the field to where?
to home, my lord.
Okay.
While she,
I'm just playing around.
Rashid.
Yes.
While she returned to home, then she saw the woman and Hafizur Rahman leaving my house, keeping another man in my house. And she asked Hafizur to take the man, but Hafizur replied that the man take alcohol, and as such, it is not possible to bring him along with them, and he would go later on. Thereafter, one Syed Ali Khan came to my house and asked him to enter into my house to see the person who was lying in my bed. Thereafter, Syed Ali Khan saw the man and tried to check his pulse and found that the man already died and some substance came out from his mouth. Thereafter, Syed Ali Khan called village Gaungura and other villagers, and they came to my house. Gaungura telephoned to the police station. Policemen came to the place of occurrence and asked me and my wife about incident, and I replied I was not present in the house. Thereafter, police took the dead body to the police station. Thereafter, some people of the village deceased came to my house and they reported that deceased came out from his house with a view to go to his father-in-law's house along with his wife. Dead body was
Just a minute. Thereafter, police took the dead body to the police station. Thereafter, some people of the village of deceased came to my house. And they reported that deceased came out from his house with a view to go to his father-in-law's house along with her. Okay, so to a different place.
lodged in the
Then
On the next day, I lodged FIR in the police station. Police came to my house and seized one jute rope. Material exhibit A is the said jute rope. Police asked me about the incident.
This
Cross my-
PW1 happens to be the grandfather of the accused.
yes, I know.
and cross my lord. I have two wives, namely Saleha and Mulukjan. Saleha left me and accused Hafizur Rahman is the son of daughter through Saleha.
Just a minute. Saleha left me and accused her as the son of my daughter through Saleha. Okay.
Yes,
So
Lordship.
Saleha's grandson.
Lordship. Saleha is his first wife.
First
my
wife.
lord. The name of my daughter is Hameda Khatun. I forgot the date of occurrence. The time which is 7 p.m. is correct, and other times mentioned in FIR and statement under section 161 of the CRP are not correct. In my FIR, I have not mentioned the reason of delay. I was confused, and for this reason, I was not filed the FIR immediately. I lodged FIR because the dead body was recovered from my house. One person wrote FIR in the police station, but I could not say his name. I cannot read and write, and as such, I could not say whether the person who wrote the FIR put signature in the FIR or not. Near my house, there is a house of Syed Ali Khan, and other house of my villager is some distance from my house. house of Ranjit Arya and Sanjeev Arya is
Okay, so
situated.
this is not important. I think.
Lordship.
Then next,
Next, my lord, PW2, my lord.
yes,
Syed Ali Khan. I know the informant after the incident. I know the accused Hafizur Rahman and Zaheda Begum. About 1 year ago, one day at 4 p.m., while I was sitting in my courtyard, then I saw the accused Hafizur Rahman came to the house of informant in the auto along with one man and one woman, and there was a child in the lap of the woman. After half an hour's, wife of the informant Mulukjan came to my house and talk with wife of the her grandson Hafizur Rahman, and came to their house with a drunken person, and drunken person is lying on their bed and asked her not to talk with him and not to disturb him. Thereafter, I asked the wife of the informant that why your grandson took a drunken person and drunken person should oust from their house. She further stated that her grandson even did not allow her to go near the drunken person. In the meantime, Hafizur arrived in my house and I asked him why he took a drunken person to his grandfather's house. Accused Hafizur replied that the drunken person drank alcohol and what can I do? He also stated that after some time he would bring the man. Thereafter, Hafizur Rahman and wife of informant left my house about 6:30 p.m. While I was taking food, then my wife reported me that the man who was took by Hafizur Rahman in the house of informant could not talk, and Hafizur left the house of the informant along with the woman and kept the man in the house of the informant. Thereafter, on getting the said information, I immediately went to the house of the informant with a torchlight and saw the man and found that his tongue was coming out from his mouth and blood was oozing from his tongue. I touched his hand to check his pulse, but I could not find his pulse, and the hand was black and cold. I was checked the leg of the man and found that the leg was become black and cold. Then I asked the informant where he was gone. Then he replied that he at the moment came to his house from market. I told the informant that the man already died. What would be happen with you? Thereafter, he went to the house of the Gaambura. I took the phone number of OC Amguri PS. I telephoned OC Burman of Amguri PS. Thereafter, we informed AMSU member of the local people and incident that the villagers and my lord always.
just a minute, then carry on.
I saw standing on the road of the meantime, accused Hafizur Rahman came there by riding bicycle along with two persons, and on seeing us, he got down from the bicycle. I told Hafizur Rahman that the man who was left by him already died, and Hafizur Rahman became surprised. Hafizur Rahman told me that he left the man in a good condition. Thereafter, the two boys who came with Hafizur Rahman ran away from the place of occurrence, and Hafizur Rahman was tried to flee, but I caught him. But I caught hold him. I took Hafizur Rahman inside the house of informant near the dead body of the person, and in the meantime, police arrived in the house of the informant. I hand over accused Hafizur Rahman, and the police saw the dead body. Police asked us about the incident. Thereafter, OC Amguri asked informant to bring the dead body to the police station, but I told the police that informant's vision power is poor, and I would bring the dead body to the police station. Accordingly, I, in a handcraft, took the dead body to the police station. On the next day, police asked the informant to file a FIR. Accordingly, informant lodged the FIR. Police came to the place of occurrence in Sage 1 Jutro. Exhibit 1 is the seizure list, and Exhibit 1 within record clause within record 1 is my signature. Material Exhibit A is the said Jutro.
Why did you come with two persons?
Because as he was drunk, lordship, I suppose
He was drunk.
I suppose he was unable to.
And why did these two boys run away?
Because
If
it
you are
is
drunk.
it is a common my lord
So
problem.
they run away. They bring to carry a drunk person and then they run away.
After hearing that he is no more.
Then they run away. Why they can walk away? Just thinking, why should they run away? And why should Hafizur try to run away? He says Hafizur Rahman also tried to
Common
flee.
intention, my lord, because after hearing that someone is no more who is
So he suddenly got scared
lost it.
and he wants to run away.
Lost.
But normal person will say, oh, it was my friend. I should go and see him instead of running away. When a friend dies, people don't run away. They usually go and see, pay their respects. They don't usually run away. Not normal. Anyway, let us see what is the cross on that aspect.
I saw the accused Hafizur Rahman came in the house of informant along with a man and a woman in an auto rickshaw. I reside on the land of informant near my house. There is a house of Babu Ali and others house of the village is situated some distance. Mulukjan Bibi reported my wife that person who was left by accused Hafizur Rahman was not talking. While I went to the house of informant, then I saw informant and his wife were in the kitchen and I entered in their dwelling house. While wife of the informant report me that the person who was left by the accused Hafizur Rahman was lying in their dwelling house, then I entered
Okay.
into
There's nothing here. Then next.
no note my lord PW3 my lord.
Yeah.
Informant is my husband. Accused Hafizur Rahman is my grandson. From that day of occurrence, I know accused Zaheda Begum. About 3 years back, one day at about 4 p.m., I saw sitting in the courtyard of Syed Ali Khan. At the time, Hafizur Rahman came to our house along with one man and the accused Zaheda Begum and auto. Hafizur Rahman took the man into our house and lying him on our bed. My hearing is poor and I could not say what discussion made by the accused Hafizur and the woman. I asked Hafizur, who is the man and woman? Then he told me that I would not recognize them. Hafizur told me that the person who was lying on the bed taken alcohol and asked me not to go near him. Thereafter, I went to field to bring goat. I returned to my house along with the goat and found that the accused person left our house keeping a man in our house. As the person was left in my house was taking alcohol, talking alcohol, so out of fear, I do not enter into our dwelling house. At that time, my husband was not at home. Thereafter, I went to the house of Syed Ali Khan and reported that the man was lying inside our dwelling house and I am out of fear, did not enter into my house. Thereafter, wife of Syed Ali came along with me, but she also afraid to enter into my dwelling house. Thereafter, my husband returned to our house and I informed my husband that Hafizur Rahman left one drunken person who is lying in our house. Thereafter, my husband along with Syed entered into our dwelling house and Syed checked the pulse of the person and told that the man already died. Thereafter, the matter was informed to the police station and police came to the place of occurrence and took the dead body. Thereafter, my husband filed a case and police came to my house and took me into the court and my statement was recorded by magistrate. My lord Cross. Accused Hafizur Rahman Zaheda Begum and the deceased person came to our house in an auto rickshaw and they stopped the auto rickshaw in front of our gate. From the gate, they walked to our house. I do not go near to the person who was lying inside our house and on bed. Except Syed Ali Khan and his wife, I have not reported the incident to any other person. I went to field to bring goat. After 1 hour, I returned to my house along with goat. But my husband returned to our house after a long interval between. I taken the goat from the field. When I returned from the field, I have not found Hafizur Rahman in our house. While my husband arrived in our house, then I reported the incident to him. He did not enter into the dwelling house and called Syed Ali Khan. After Syed Ali Khan telephoned the people arrived in our house. I could not say how the man died.
Yes, next.
Next PW deposition of PW4 minus honor. On 18/9/16, I was working at JSB Hospital as senior medical and health officer, Kajalgaon. On that day, I have done postmortem on the dead body of Akhtar Hussain, male age about 25 years, son of Muhammad Abdul Mannan, resident of village Bandhal PS Amguri, connection with Amguri PS GD 337 dated so the dead body was accompanied and identified by UBC 232 NIL of N. Hossain Ali. During the performing postmortem examination, I found the following physical appearance. The person was aged about 25 years, having average skill, swarthy complexion, wearing blue t-shirt and jeans, eye closed and mouth closed. There was bleeding noise. Early rigor mortis present, mark of pleasure on neck decision, a ligature mark partially innervating the neck, transversely about thyroid cartilages present, more prominent at the front throat side. One section, a compressed sub tissue under the ligation, mark no other external injuries found. Opinion. Cause of death is due to asphyxia as a result of strangulating, which is homicidal and anti-mortem in nature. Time since that 24 to 48 hours. Exhibit 2 is the postmortem report, and exhibit 2.1 is my signature. In in reference to Amguri PS GD entry number so and so, dated so and so. I have done the postmortem examination on the dead body. I have not taken the signature of the constable who was got the dead body in the hospital. I have not found any external injury except the injury on the neck of the dead body.
Next,
My lord, PW 5 or not. I know the information. Amir Rahman, informant actually. my lord. I do not.
five is of no use. Is it? Is there any relevance, the evidence of five? I don't think, only hearsay.
Lordship,
So go to 7,
Lordship.
6, I mean 6.
6, my lord. 6 is important, my lord.
Yes, that is about 6.
Honor, I know the informant. I know the accused person about 5 years ago at about 4 p.m. I was in my house, and at the time the wife of informant, namely Mulukjan Bibi, was also present at my house. Thereafter, Mulukjan Bibi went to her house. The house of Mulukjan Bibi is situated at 50 meters from my house. After about 1 hour, I went to the house of Mulukjan, and then I saw the accused Sri Hafizul Rahman was sitting in chair and another person was lying on the bed, and at the corner of the said bed, accused Zaheda was sitting. Thereafter, I asked Asante Zaheda as to what had happened, and then the accused Asante Zaheda told that the person lying on the bed is her husband, and that her husband became ill, as such he was lying on the bed. At the time, the person who was lying on the bed spoke and asked the accused person as to where had they brought him, to which the accused person asked him to keep lying down, and thereafter I returned back to my house. The accused Sri Hafizul Rahman had visited the house of informant on earlier occasion also, and so I know him. But I saw the accused Asante Jaheda from the first time on the day. Thereafter, I came back to my house, and my husband also came, and I gave him food, and then I again went to the house of Mulukjan Bibi, and while on the way to her house, I saw the accused person were coming out of the house from Mulukjan Bibi and were going away. When I saw the accused person, I asked them as to where they were going, and also asked them as to why they were living behind the said person lying on the bed, to which the accused person told me that they would come later on, take back the said person. Thereafter, I again came back to my house and told my husband about the incident, and told him the accused person left by keeping the sick person lying on the bed, and then my husband finished his food and went to house of Mulugjan Bibi and saw the said person was lying on the bed and he inspected the said person and found the said person was dead. Thereafter, my husband also narrated the above facts and information. Thereafter, the police was informed and police came to the place of occurrence and took the dead body. The police recorded my statement and my statement was also recorded under section 164 of CRPC. Cross matter. I reside on the land of the informant. One Babul Rahman, one Ranjit Sanjeev have their house near the house of informant. While Mulugjan Bibi was sitting in my house, the accused person came to her house and I saw them coming out. After about 1 hour, I went on my own to the house of Mulugjan Bibi. Thereafter, I again went to the house of Mulugjan Bibi after about 2 hours or so because in the meantime, I cooked food, also offered namas. After 2 hours later, my husband went to the house of Mulugjan Bibi and I followed him after some time. When my husband went to the house of Mulugjan Bibi, the informant was present in his house. My husband went to the house of Mulugjan Bibi after about 2 hours. Since the accused person left the house of Mulugjan Bibi, I cannot say how and what manner the said person died.
Next. CW7.
My lord.
CW7 is the IO.
My lord. On 16/9/2016, I was posted at Amguri PS SI of police. On that day, at about 8:30 p.m., I have received an information over telephone from one Syed Ali Khan of village number 2, Sikapara, to the effect of the accused Hafizur Rahman and one lady murdered one person at the house of his relative Sri Hamay Rahman. Upon receipt of information, I made ZD entry number 337 dated 16/9/16 and proceed to the place of occurrence along with other police personnel. Exhibit 4 is the said extract copy of ZD entry. So and so. Exhibit 4(1) is my signature. Thereafter, I reached the place of occurrence and found a dead body lying on the bed inside the room in the said in the house of Sri Hamiraman. Photographs of the dead body at the place of occurrence was taken. M Exhibit B and M Exhibit C are those photographs. The learned counsel for the defense objection of above material exhibit is on the ground that the above photographs were not filed along with the charge sheet and did not form part of the record. The above objection is recorded and would be decided at the time of the judgment. Thereafter, I made inquest of the decision, prepared a report. Exhibit 3 is the said report, inquest report, and Exhibit 3(2) is my signature. Thereafter, I prepare the sketch map of the place of occurrence. Exhibit 4 is the said sketch map, and Exhibit 4(1) is my signature. I also recorded the statement of the witness and sent the dead body of the deceased to the police station. The accused Hafizur Rahman was apprehended by the local public on the night itself, and he was handed over to me the place of occurrence, and I also brought him to the police station. The accused was interrogated, and during interrogation, he confessed to the crime before me and stated that he, along with co-accused, strangulated the deceased with a jute rope. Thereafter, the accused was taken to the place of occurrence when he showed me the jute rope lying on the floor at the corner of the room in which the deceased was found. Thereafter, on the being shown by accused, I see is the said jute rope. White Exhibit 1 and Exhibit 1(2) is my signature. And Exhibit A is said the jute rope. The dead body of the deceased was sent for the postmortem, and later on I collect the postmortem report. I also sent two witnesses, namely Jaheda Khatun and Mulugjan, from the recording their statement under Section 164 shares. After completion of the investigation based on the materials collected, I have submitted charge sheet against the accused person under Section 302. 34 of IPC. Exhibit 6 is the said charge sheet of Exhibit 6(1) is my signature. Cross-examination. On 16/9, so and so at about 8:30 p.m., I made the first entry in the CD. The distance between the Amguri police station and the place of occurrence is 5-6 kilometers. Syed Ali Khan informed me at about 8:30 p.m. that the incident over telephone. There were many local persons at the time of handing over the accused to me, but I did not mention their names. I connect I cannot say whether the room from which the dead body was recovered was used by Hamid Rahman as bedroom or otherwise. The house of Hamid Rahman consists of one room and one kitchen. No executive magistrate was present at the time when I conducted the inquest. The dead body was brought to the police station by us, but I do not remember now whether we brought the dead body in a police vehicle or not. I did not make any prayer before the court for the recording confessional statement of the accused Hafizur Rahman. It is not a fact that accused did not lead me to the discovery of said Judro. It is not a fact that the accused never confessed before me and never led me to the place of occurrence and did not show me the Judro. The dead body was sent for the post-mortem on 17/9/2016 at about 1:10 p.m. It is not a fact that I had not properly investigated the case and filed the search sheet against the accused person without sufficient material against them.
Here, IU talks about 164 statement, but I did not find it on record. It's not in the paper book.
164 statement. Anyway, the appellants have not given any 164 statement, correct?
No. There are the witnesses.
The witnesses have given. So how does that matter?
Doesn't matter, but
The-
he talks about 164.
But
Even
that is
the
not
other
there in the
witness,
paper.
BW6 also talks about 164, but it's not on record, not in the paper book. I have not checked the record.
Anyway, so
Should I go for the my appeal, my lord, 81?
no, let's go to 313. 313, I think you have not denied that you all were there. Okay, then now what is your case?
My lord, my humble submission, lordship, there is no eyewitness, lordship, and I have a small kid, lordship.
No eyewitness and you've got a small,
Child, my lord,
you've got a small child. So
but and a victim is my husband, my lord.
victim is husband.
My lord.
So you're
And
innocent.
the jute rope which was, my lord, recovered, that is not sent to the forensic, my lord.
For what?
Whether I strangulating my husband or not, my lord.
Is it, how will they, will be something be there?
And two lady who is Mulukjan and something Jaheda Khatun. They are very much
Huh?
Lordship,
You all were last seen together with them, with him,
Lordship,
and then you all went.
Lordship.
And when was he found dead? What time?
Time is not mentioned, my lord.
Approximately 2 hours.
Approximately 12.
When I left my husband. he
From where
was
do you
alive,
get
my-
the 2 hours?
CW6, Lakshmi, my note says, I'll check it up once.
Nafizur Rahman was in intention, Lordship, that he will bring him back.
From the death.
He is the advocate for Hafizur Malik.
I will ask him, he'll get his turn. That's all. Anything else?
Malik.
Yes.
Lordship, page 19 of the paper book.
Yes.
Cross-examination. After 2 hours later, my husband went to the house of the Mulukjan and I followed him after some time. When my husband went to the house of the Mulukjan Bibi, the informant was also present in his house. My husband went to the house of the Mulukjan Bibi after about 2 hours. So the accused persons left the house of the Mulukjan Bibi. At the time, he was dead.
Where is it?
Page 19 of the paper book.
Yes. Cross.
Cross part, second paragraph, last line.
Okay.
Second last line. After 2 hours later, my husband went to the house of Muluk Sandi.
Okay.
May I please have a-
Yes.
My lord, it appears from the judgment, my lord, that the learned court below convicted the appellant only on the basis of the circumstantial evidence, and more particularly, my lord, the evidence of PW2 and PW6. The PW2 and PW6, they are the husband and wife, my lord.
PW2 is so conviction based on evidence of PW2 and PW6.
My lord,
Husband and wife.
they are husband and wife, my lord.
Husband and wife. So what is wrong?
Well, while passing the judgment, my lord, the learned court below has applied three theories, my lord. First is motive, and second is, my lord, the last scene theory,
Motive, then
last scene theory,
last scene theory,
and third is, my lord, the leading to discovery.
and
Leading to discovery, my lord.
leading to discovery.
My lord. Now, my lord, in the judgment,
Now, you see, what is the motive?
my lord, I'm explaining. Now, in the judgment, my lord, while passed the judgment by the learned court below, in para 50 clause 1, my lord, kindly see my appeal memo, page 43. Page 43 of my appeal memo, my lord,
Yes.
para 50,
Yes.
may I read, my lord?
Yes.
In view of the above discussion, let me narrate the circumstances.
Page
which-
43.
Page 43, my lord. My lord, not in paper book, my lord, in my lord, appeal memo, my lord. In item number 20, my lord. Criminal appeal
Give me item
practice.
20.
Page 43, my lord. Para 50, my lord.
Appeal memo, page 43.
My lord.
Criminal appeal 36,
my lord.
page 40.
It would be, your lordship, page 62 of our papers. I don't
No,
know
page
what.
40, okay.
Page 60, para 50.
Page 40.
62, para 50.
My lord, in the appeal memo, page 43, para 50, my lord. And in paper book, my lord, page 63, my lord, page 62, my lord, in paper book.
Yeah.
I am reading from my lord, appeal memo, my lord.
Yes.
In view of the above discussion, let me narrate the circumstances which are proved beyond any doubt by the prosecution and which points towards the guilt of the accused persons. The circumstances against the accused persons are: clause 1. The accused Srimati Jahida Begum was the wife of the deceased, and after the death of the deceased, both the accused person married, which prima facie shows that the accused person might have been having an illicit affair at the time of alleged occurrence, and they murdered the deceased so that they could come together. The above facts clearly proves that the accused person had the motive to commit the murder of the deceased. Now, my lord, my submission is that here the prosecution has examined as many as 7 witnesses to prove the case, my lord. But in no their statement, in evidence of 1 to 7, in their statement, nowhere it is found that the 2 accused persons, that is the appellant before the lordship, they have married. Now, my lord, kindly see the evidence as the lordship already gone to the evidence.
Okay. Forget about the motive. Then forget about this. They were having illicit affair.
My lord.
Forget that. That is not proved. Then
Now, my lord, the second theory has applied, that is last seen theory, my lord. And for that, my lord, the learned court has discussed from para 20 to para 23. What you will find, page 29 in my appeal memo.
we'll take it up after Act 2, huh?
My lord.
Been having an illicit affair.
My lord. But, my lord, the prosecution has examined as many as 7 witnesses.
There's nothing there. There's nothing there. Next.
There is nothing.
Last scene theory.
Now, my lord, the last scene theory. My lord, kindly come to page number 29 of my appeal memo. The para 19 of the judgment. There are 19 to 23 of the judgment, my lord. 19 to 23.
Page 29.
Page 29.
Para 19.
19 to 23, my lord.
Yes.
Here, my lord, the learned court below has discussed about the last scene theory, my lord. Para 19, my lord.
Yes.
The accused person had, however, denied that they had murdered the deceased Akhtar Hussain. According to the accused person, the deceased Akhtar Hussain was alive when they left him. They further stated that they do not know how Akhtar Hussain died. Para 20, my lord. At this juncture, the evidence of PW6, Srimati Jahida Khatun, is of significance because she is the last person who had seen the deceased alive in the company of the accused persons. The PW6, Srimati Jahida Khatun, had specifically stated that the deceased spoke in her presence and asked the accused person where they had brought him, to which the accused person asked him to keep lying down, and thereafter the PW6 left the house of Sri Hamir Rahman, and after that no one saw the deceased alive. There is absolutely nothing on the record to doubt or disbelieve the evidence of PW6, Srimati Jahida Khatun, and moreover, the defense had failed to cross-examine the PW6 in this regard. As such, her testimony to that effect, the deceased spoke in her presence, cannot be doubted or disbelieved. It is further seen that, except the accused person and the deceased, there was no one else at the house of Sri Hamir Rahman for a considerably long period of time. The PW3, Srimati Mulokjan Khatun, had specifically stated her husband, Sri Hamir Rahman, was not present at that house when the accused person came along with the deceased, and She further stated that after some time she went to the fields to fetch her goat by leaving behind the accused persons and the deceased at her house. And when she returned back, after about an hour so, she saw the deceased accused persons had already left and only the deceased was lying on the bed. But she did not go near the deceased out of fear, as the accused Sri Hafizur Rahman told her that the deceased was drunk. Para 22, madam. PW6. Srimati Jaheda Khatun is another person who went to the house of Sri Hamid Rahman when the accused persons were present along with the deceased, and she had also stated that she also returned back soon by leaving behind the accused person and the deceased, and thereafter, and after some time, she saw the accused person leaving the house of Hamid Rahman by leaving behind the deceased. Para 23. It is therefore seen that accused persons and the deceased were at the house of Hamid Rahman alone for a considerably long period of time, and they had sufficient time and opportunity to commit the offense. Now, my lord, here, my lord, the evidence of PW1, PW2, and PW6 are important, my lord. So, my lord, kindly peruse the evidence of PW1.
PW1, PW2.
PW1, PW2, and PW6.
Yeah.
My lord, the evidence of PW1 in paper book, page 8, my lord. Paper book. Very fine. I am the informant of this case. I know the accused Hafizur Rahman and Zaheda Begum. I did not know Akhtar Hussain. About 3 years ago, one morning, I went for daily wage work. I worked up to 5 p.m. and thereafter I went nearby market, and from market I returned to house at about 7 p.m. When I arrived in my house, then I saw one person lying on the bed inside of my house. Thereafter, I asked my wife who is the person. Then my wife replied that my grandson Hafizur Rahman came to our house along with one woman and another man. The man was the husband of the woman. Thereafter, by keeping them in my house, she went to field for the taking bath. While she returned to home, she saw the woman and the Hafizur Rahman leaving my house, keeping another man in my house, and she asked Hafizur to take the man, but Hafizur replied that the man take alcohol. As such, it is not possible to bring him along with them, and he would go later on. Hereafter, one Syed Ali Khan came to my house, and I asked him to enter into my house to see the person who was lying in the bed. Now, my lord, this part is relevant so far as the last scene theory, my lord, because as per the statement of the informant, he reached home at 7 p.m. Now, my lord, kindly see the cross-examination part of PW1. I have two wives, namely Saleha and Mulakjan. Saleha left me and accused Hafizur Rahman is the son of my daughter through Saleha. The name of my daughter is Hamida Khatun. I forgot the date of occurrence. The time, which is 7 p.m., is correct, and other times mentioned in the FIR and the statement under section 161 of CRPC are not correct. So, my lord, the time as per the statement of the PW1, the time is 7 p.m. Now, my lord, kindly come to the evidence of PW2. The PW2 and PW6, they both are husband and wife, and they are the neighbors of Hamid Rahman.
Yes.
I know the informant. After that incident, I know the accused Hafizur Rahman and Zaheda Begum. About 1 year ago, one day at 4 p.m., while I was sitting in my courtyard. Then I saw that the accused Hafizur Rahman came to the house of the informant in an auto along with one man and one woman. There was a child in the lap of the woman. After half an hour, wife of the informant Mulak Jan came to my house and talked with the wife that her grandson Hafizur Rahman came to their house with a drunken person, and the drunken person is lying on their bed, and asked her not to talk with him and not to disturb him. Thereafter, I asked the wife of the informant that why your grandson took a drunken person and a drunken person should out from their house. She further stated that,
Who is this informant? Is not PW1.
yes, ma'am, informant is the PW1.
Then who is this?
Mulak
Maluk Jan.
He is the wife of the informant.
Wife of the informant.
Wife of the informant.
Okay.
And he is like grandmother.
Grandmother of the
Okay.
accused.
Okay. Maluk Jan is the wife of the informant.
So as per the statement of the PW1, PW2, he saw that at 4 p.m., this accused person along with the deceased, they came to the house of the PW1. She further stated that her grandson even did not allow her to go near the drunken person. In the meantime, Hafizur arrived in my house and I asked him why he took a drunken person to his grandfather's house. That means, my lord, at 4:30. 4:30, the accused person, the appellant before the lordship, he is present in the house of PW2, my lord. In the meantime, Hafizur Rahman arrived in my house and I asked him why he took the drunken person to grandfather's house. Accused Hafizur replied that the person drank alcohol and what can I do? He also stated that after some time he would bring a man. Thereafter, the Hafizur Rahman and the wife of the informant left my house. Now, my lord, at about 6:30 p.m., that is at 4:30, I am at the house of the PW2. At about 6:30 p.m., while I was taking food, then my wife reported me the man who was took by Hafizur Rahman in the house of the informant could not talk, and Hafizur left the house of the informant along with the woman and kept the man in the house of the informant. Thereafter, on getting the said information, I immediately, that is at 6:30, I immediately went to the house of the informant with a torchlight and saw the man and found that his tongue was coming out from the mouth and blood was oozing from the tongue. I touched his hand, checked his pulse, but I could not find his pulse, and the hand was black and cold. I also checked the leg of the man and found that the leg also become black and cold. Then I asked the informant. So, my lord, as per the PW2, the informant is present at that time. That is at 6:30. But the PW1, he has stated that time is 7 p.m. Now, my lord, then I asked the informant where he was gone. Then he replied that he at that moment came to his house from the market. PW2 stated in his evidence that he saw that the appellant, both appellants and the deceased were come to the house of the PW1 at 4 p.m. and at 4:30, the appellant before the lordship was present in his house, and 6:30, when his wife stated that the person, the deceased person, was not talking, then he went to the house of the informant at 6:30 p.m. And at 6:30 p.m., the PW stated that the informant is present. Now, my lord, kindly come to the page number 19 of the paper room. That is the cross-examination part of the PW6, my lord.
Yes.
Here, my lord, I am submitting or establishing the time, my lord. I reside on the land of the informant, so and so. While Mulak Jan Bibi was sitting in my house, The accused person came to her house and I saw them coming. After about 1 hour, I went to my own to the house of the Mulakjan Bibi. Thereafter, I again went to the house of the Mulakjan Bibi after about 2 hours, also because in the meantime, I cooked food and also offered namaz. After 2 hours later, my husband went to the house of the Mulakjan Bibi and I followed there after some time. Now the last part is important, my lord. When my husband went to the house of Mulakjan Bibi, the informant was also present in his house. My husband went to the house of Mulakjan Bibi after about 2 hours, since the accused person left the house of Mulakjan Bibi. My lord, as per the statement of the cross-examination part of the PW6, she stated that her husband went to the house of the informant. After 2 hours, the accused person left the house. That is, my lord, her husband went to the house of the informant at 6:30, and by meaning thereby that at 4:30, the accused person left the house of the informant, my lord.
Where is that?
My lord, this is there, my lord. In the last slide, my lord. My husband went to the house of Mulakjan Bibi after about 2 hours, since the accused person left the house of Mulakjan Bibi. As per the statement of the PW2, he went to the house of the informant or Mulakjan Bibi.
After 2 hours, so how can it be 4:30?
It is 4:30, my lord, because 2 hours since the accused person left.
When did the accused persons come to the house in the first place?
At 4 p.m.
4 p.m. After 2 hours from 4 p.m. will be how much?
No, my lord. Here, my lord, the PW2 stated in his evidence that at 4:30, the accused person is present in the house of the PW2. PW2 and 6 are they were husband and wife, my lord.
PW2 said what?
PW2 states in his evidence, my lord. It's 12, my lord. It's 12.
Page 12 is PW3.
Sorry, my lord. Page 10, my lord. My lord, 1, 2, 3, 4, fifth line, my lord.
Yes.
After half an hour, wife of the informant Mulakjan came to my house and talked with wife that her grandson Hafizur Rahman came to their house with a drunken person, and the drunken person is lying on their bed and asked her not to talk with him and not to disturb. Thereafter, I asked the wife of the informant that why your grandson took the drunken person and drunken person shoot out from their house.
Where is the question of informant coming in?
My lord, in the meantime, my lord, Hafizur arrived in my house. In the meantime, my lord, that is 4:30.
Correct. Then he went back.
That is my case, my lord.
So
My lord, my humble submission before your lordship, my lord, that PW2 stated at 4:30, I am present in the house of the PW2. And PW6 stated that her husband went to the place of the informant at 6:30. That is since 2 hours back, the accused person left the house of the informant, my lord. Now, my lord, can you come to page number 7 once, my lord, my appeal memo, my lord.
You have got a paper book. Why do you have to take us through?
My lord, my grounds, my lord. Here, my lord, I have submitted my grounds, my lord. Therefore, my lord, it will be clear, my lord.
Page 7, yes.
Page 7, my lord. Third paragraph, my lord.
Yes.
Be it mentioned here in that the evidence of the informant clearly says that he returned home at 7 p.m. on the day of incidents. Be it further mentioned here that from the evidence of PW2, it's seen that the accused person came to the place of occurrence on the aforesaid date at around 4 p.m. Later, half an hour, the wife of the informant, PW3, went to the PW2's home, and at that very time, the accused Hafizur Rahman also went to the PW2's home. Now, if the version of the PW6 in cross-examination is perused, it is clear that her husband, that is PW2, went to the place of occurrence after 2 hours from the time the accused left the place of occurrence. Such version of the aforesaid PWs only suggests that there was a time gap of 3 hours from the time the accused reached the place of occurrence, that is 4 p.m. to 7 p.m. That is discovery of the disease being dead by PW2. Again, as aforesaid PW6 deposed in cross that the accused left the place of occurrence 2 hours before the body was discovered. It is only suggests that the accused was with the deceased alone for maybe 15 or so, as from the evidence of PW2. It is clear that the accused and the informant's wife went to the house of the PW2 after half an hour from the arrival, that is 4 p.m. And at that time, the deceased was alive. Now, the second part, be it further and alternatively mentioned that the learned court below in para number 26 has stated the PW2 in his version has said that he was eating at his home at 6:30 p.m. and upon being informed by his wife that the person that the accused accompanied was still lying on the bed, he immediately went to the informant place and found that the person was dead. If the defense presented in the instant para is clearly scrutinized there, then the version of the immediately leaving the informant's house at 6:30 only clarifies that the accused in fact had no opportunity of being alone with the deceased.
Yes. Then
Fact being that the accused had reached the place of occurrence at 4 p.m. as the aforesaid when the accused went to the PW's house half an hour later, that is 4:30 p.m. And as PW6 has deposed that the accused left the place of occurrence 2 hours before her husband arrived at the place of occurrence, then the accused in fact had no time alone with the deceased, as because the accused arrived at 4 p.m. and went to the PW's house at 4:30 p.m. and has left the place of occurrence finally 2 hours before the arrival of the husband at 6:30 p.m. So, my lord, in para 23 of the judgment, my lord, the learned court held that the accused person get sufficient time to commit the crime. Therefore, my lord, I have stated, my lord, the findings the accused had sufficient time to cause the murder is not understandable. Rather, such finding of the learned court below suggests that he was hurriedly past the influence of judgment, overlooking the version of the aforementioned PW's, my lord.
That next.
Now, my lord, the third theory has been applied. That is the leading to discovery, my lord. My lord will find para 31, 32, 34, and 38.
Para of what?
Of my appeal memo, my lord. Lordship may is the paper book, my lord.
Para?
Para 31, 32, 34, and 38
of the judgment.
Of the judgment, my lord. Here the discuss about the leading to discovery. Well, in a paper book, page number 55, my lord.
Yes.
Now, let me examine the evidence of the investigating officer, Sri Jitesh Burman, PW7, as he is a material witness for the prosecution.
Which para are you reading?
Para 31, my lord.
31.
51.
That is from para page 54.
53, my lord. In paper book, my lord.
In mine it's 54. Okay, 53. Have 53. Okay.
Now let me examine the evidence of investigating officer Sri Jitesh Burman, PW7, as he is a material witness for the prosecution. PW7 Sri Jitesh Burman had deposed that on 16/9/2016, he received a telephone call at 8:30 p.m. from PW2 Sri Syed Ali Khan to effect that the accused person had murdered Akhtar Hussain at the house of Sri Hamir Rahman, and accordingly he made GD entry number so and so, dated so and proceeded to the place of occurrence. The extract copy of the GD entry and dated so and so marked as Exhibit 4. The PW7 had deposed that when he reached the place of occurrence, he found that the dead body lying on the bed inside the room of Sri Hamir Rahman, and thereafter the photographs of the dead body was taken. The PW7 had stated that the accused Sri Hamir Rahman was apprehended by the local person and handed over to him. So he brought the accused Sri Hafizur Rahman to the police station and interrogated the accused, and during interrogation, the accused confessed before him that he and the co-accused had murdered the deceased Akhtar Hussain by strangulating him with the jute rope, and so the accused was taken to the place of occurrence, and at the place of occurrence, the accused pointed out to the jute rope lying in the corner of the room which the deceased was found dead. Now, my lord, regarding the discovery of the jute rope, my lord, the Caesar witness has stated different places, my lord. As per the statement of the PW7, the jute rope was lying in the corner of the room. But my lord, if your lordship go to the statement of the PW1,
Yes.
my lord, in cross-examination, page 9,
Yes.
13 line, my lord,
Yes.
the seized jute rope was found on the one bed inside my house, not at the corner of the room, my lord. Page 9, my lord, 13 line, my lord, cross-examination.
39 page.
Page 9, my lord. The cross-examination part of PW1. In his cross-examination, he stated the seized jute rope was found on the one bed inside my house.
Same house, anyway.
Now, my lord, PW5. He also stated the different place.
Caesar witness.
Yes, my lord.
Yes.
My lord, in SIF, evidence in SIF, my lord.
Yes.
14 line, my lord. Police also seized one rope from near the bed where the dead body was lying.
Page.
Page, my lord, 16 in paper book, my lord.
Near the bed.
Near the bed, my lord.
Yes.
So, my lord, my humble submission before your lordship, my lord, there is no corroboration to the statement of the IO regarding this PW7 regarding the discovery of the rope, my lord. The statement was different, my lord. Now, and prosecution has also failed to prove the said rope was used for the said crime as a murder weapon, as the same is not sent to the FSL. So it remains a doubt, my lord.
What will the FSL do? What will the FSL say? That it was used for the crime? What examination can be done on a jute rope?
My lord, my fingerprints will be there, my lord.
Huh? In a jute rope?
My lord,
In a jute rope, there will be a fingerprint. Can there be a fingerprint on your gown or on your coat?
otherwise, my submission is that, my lord, that said jute rope was not, my lord, sent to the FSL, my lord.
Jute rope was not sent to FSL. to examine the same for fingerprints, huh?
My lord.
Anything else?
My lord, my lord, kindly come to the evidence of the medical officer,
Yes.
page 14, my lord, of the paper book, my lord. Only first part, my lord.
Yes.
My lord, the fourth line, the dead body was accompanied and identified by UBC 232 Ainul Haq and Hussein Ali. That two person, my lord, who identified the dead body, that two person was not made as a prosecution witness and they were not examined, my lord.
You mean to say that why do you need to identify the dead body? What will happen?
My lord,
You mean to say that there was no dead body?
there is a dead body. The dead body might not be the disease, the person which we're discussing in this case, my lord.
Oh, so that is not that person who died is not is not your husband, your earlier husband. Is it your case?
No, my lord.
Is it your case that it is not her? It is not your wife's ex-husband?
No, my lord. My submission before your lordship, my lord. It is the case of the prosecution, my lord. That two person, because the medical officer in his cross-examination stated that the dead body was identified by the two, my lord, the UBC person, my lord. But these two persons were not examined, my lord.
Have you put the prosecution witnesses to any questioning with regard to the fact that the person who died is not the ex-husband or not the deceased husband of your present wife?
My lord, that is not there, my lord.
Then, okay, is it your case at any time in the trial court or even here
My lord.
in your pleadings that the dead body is not Mr. So and so? Is it
My
your
lord,
case?
why I am submitting, my lord? The PW2 in his statement, my lord. My lord, kindly pay this, my lord. PW2 in his statement, in evidence, page 10, my lord. Page 10, my lord.
Page 10.
In
Yes.
paper book, my lord.
Yeah.
2019, my lord. The 19 line, my lord. Thereafter, on getting the said information, I immediately went to the house of the informant with a torchlight and saw the man and found that his tongue was coming out from his mouth. So, but the inquest report says his tongue is not coming from the mouth, my lord.
Not coming out of the mouth.
My lord, the inquest
So-
report which you will find.
Someone must have stuffed it back in or something. What does it matter? It's a dead man. It is not in dispute that it is this one's wife.
No, my lord,
How
to
does
bring
it
on.
matter?
So therefore, I have submitted this down, my lord, because the PW2 stated different, PW6 stated different, my lord. Now-
Is it your case that the person who died is somebody else and not the person who they claim to be is dead? Is it your case?
No, my lord.
Yeah.
Now, my lord,
For the sake of argument, why do you have to
my
argue?
lord, my lord, my submission again, my lord, regarding the time of the incident, the different PWs have stated differently, my lord. PW1 says.
Yes,
his
we have got
statements-
no point repeating over wasting
My lord,
time.
my lord, my lord, my lord.
So
And regarding-
basically your case is that there was no illicit affair. Then there was the last because of the last scene theory would not work because of the different timings given.
My lord.
And then the other thing you're saying
Leading to
is that
discovery.
the question of leading to discovery is also suspect, as the jute rope was found in different places as per the evidence given by the different witnesses.
My lord,
And lastly, that the jute rope was not sent to the FSL
my lord,
to examine the same for fingerprints of the appellant.
my lord,
Correct. That's all.
my lord.
And,
My lord, another-
and one more is that the persons who identified the dead body were not examined as witnesses.
And my lord, the time of the incident, my lord.
Time of the incident is what? Is not sure. According to you. But it happened. That is for sure. Otherwise, you won't have a dead body.
No, my lord, the time of the incident, as per the PW1 stated, it is 7 p.m. PW6 2 says it is 6:30, and PW5 says, my lord, it's 6 p.m.
Okay, so time of the incident.
My lord.
Okay.
PW1 says, my lord, it is 7 p.m.
Okay.
My lord, my lord, submission before a lordship.
Yes.
My lord, regarding the information given to the police, my lord, who has given the information to the police? That PW1 says, my lord, the information was given by Kavura in his statement, my lord. And PW2 says he has himself given the information to the police. PW5 says in his in evidence in seat, he informed the police, but in cross-examination, he state, my lord, one Mubarak Ali, he has informed the police, my lord. So there is, regarding the information to the police, my lord, the statement is different, my lord.
So how is that? How does that prejudice you?
No, my lord, I have submitting before the time of, my lord, the time. That is the last scene theory, which has been stated by the learned code below, my lord. Otherwise, my lord, my submission before your lordship, my lord, that this, my lord, it is a settled law, my lord, that, my lord, the inference drawn by the court, my lord, have to be on the basis of, my lord, some established facts, my lord, and, my lord, and not on the presumption, my lord. That is my submission, my lord.
My lord,
Yes.
I have a small point, my lord.
Yes.
The incident took place at the house of Mulukjan.
Correct.
That is the informant, wife of Amir Rahman.
Yeah.
And Jaida Khatun, who is the neighbor or the lady who stayed there in the house of Syed Ali, I mean Amir Rahman, she is very much excited more than the Amir Rahman. Amir Rahman and Jaida.
Where's the excitement? I don't know. Where's the excitement?
Lordship, must have left.
Yes, madam.
Lordship, in the instant case, the more evident witnesses are PW1, PW2, and PW6. PW1, who lost the FIR, happens to be the grandfather of the accused appellant Hafizur, my lord. PW2, who resides in the land of the informant, your lordship, he is a prime witness to the occurrence, as well as PW6, who is the
Prime
wife
witness to the occurrence of what?
to the circumstances, your lordship. PW2 most relevant witness, my lord, PW2 and PW6. Lordship, they have here hammering on a point regarding time, your lordship, time factor. My respectful submission is that if your lordship goes into evidence of PW2, there's only proximity of 1.5 hour. So your lordship, it's very
Discrepancy,
small.
minor discrepancy.
Minor discrepancy might be because occurrence had taken place in 2016, substantive evidence after 3 years. So there might be little bit of discrepancy here and there, which is not patent to the prosecution case. Your lordship, at 4 o'clock, the accused persons were seen in the residence of the PW1 and 2, my lord. PW1, Amir Rahman, and thereafter, lordship, PW6 informed PW2 at about 6:30 about the condition of the deceased person. And prior to that only, lordship, may kindly have a look. May I repeat the evidence of PW2 once, my lord? May I read it once? I know the informant. After that incident, I know the accused Hafizur and Jaheda. About 1 year ago, one day at 4 p.m., while I was sitting in my courtyard, then I saw the accused Hafizur Rahman came to the house of the informant in an auto rickshaw along with one man and one woman, and there was a child in the lap of the woman. After half an hour, wife of the informant Muluk Jan came to my house and talked with wife that her grandson Hafizur Rahman came to their house with a drunken person and a drunken person is lying on their bed and asked her not to talk with him and not to disturb him. Thereafter, I asked the wife of the informant that why your grandson took a drunken man and a drunken person should oust from their house. She further stated that her grandson even did not allow her to go near the drunken person. In the meantime, Hafizur arrived in my house and I asked him why he took a drunken person to his grandfather's house. Accused Hafizur replied that a person drank alcohol and what can I do? He also stated that after some time he could bring the man. Then after Hafizur Rahman and wife of the informant left my house. At about 6:30 p.m., while I was taking food, your lordship will kindly note this timing, my lord. At about 6:30 p.m., while I was taking food, then my wife reported me that a man who took by Hafizur Rahman in the house of the informant could not talk, and Hafizur left the house of the informant along with the woman and kept the man in the house of the informant. Thereafter, on getting this information, I immediately went to the house of the informant and with a torchlight and saw the man and found that his tongue was coming out from his mouth and blood was oozing out from his tongue. As I touched his hand to check his pulse, but I could not find his pulse and that hand was black and cold. I also checked the leg of the man and found that the leg also became black and cold. Then I asked the informant where he was gone. Then he replied that he at a moment came to his house from the market. I told the informant that a man already died and what would be happen with you. Lordship, so time factor is 4 o'clock and prior to 6:30 because 6:30 wife of PW2 came and informed him. So prior to that, Lordship, the person was condition was not good, your Lordship. He was dead. And this person's they left and your Lordship will kindly take into account the conduct. One happens to be the husband of the accused, appellant Jaheda. She left her husband and went with somebody else, your Lordship. And subsequent conduct, he left there. Nobody was there to attend.
She left behind her drunken husband.
Has to be, she has to be beside her, beside him, my lord.
Not exactly. He's angry. He doesn't want to be beside a drunken.
And thereafter they have left him like that, your lordship. And your lordship, there's a leading to discovery, and whatever they have pointed out, your lordship, the discrepancy as regards the place of Caesar. But that was not put to the IO, your lordship. So all these factors and time factors, very less, close proximity of time. So all these factors, if your lordship couple into them, that evidence goes against them, your lordship. They are the perpetrator of that.
That's all.
Lordship. And defect in the investigation, non-examination or parcel identifying the dead body is not fatal to the prosecution case. I've got 2 judgments, I'll give the copies later. Proximity of time factor, minor. Last seen theory, 2003 8 SCC 93.
2003. Volume?
8 SCC 93.
93.
Amit alias Amit, Lordship.
This is for which?
Last in theory, my lord. There are 9. In Mohibur Rahman case 2002 6 SCC 715, it has been observed that there may be cases where an account of para 9.
9.
My lord. There may be cases where on account of close proximity of place and time between the event of the accused having been last seen with a deceased and a factum of death, a rational mind may be persuaded to reach an irresistible conclusion that either the accused should explain how and in what circumstances the victim suffered the death or should own the liability for the homicide. Here it has been established that the date took place on 28 between 3 and 4 p.m. It is just about that much time that appellant and the deceased were last seen by PW1 and 11. No explanation has been offered in a statement by the appellant recorded on 313. His defense is of complete denial. Thus, the conviction for the offense under section 302-370 has been rightly recorded by the court of session F1 by the High Court. In 313, they have said they left the dead body in the residence of the PW1. They did not deny so.
in 313.
Yes, they had said. Lordship,
Page?
may I check it up once? Officer Rahman's 313,
22.
page 22. Question number 1, page 22 of the paper book. Your Lordship. It has come in evidence that on 16/9 during evening, you along with the co-accused Jaheda Begum and the deceased after
This is all.
Hussein.
This is- Yeah,
Yes.
yeah. Well,
Page 22 of my paper book, Your Lordship. Question number 1 answer.
No, they left behind the person, but did they say that they left behind a dead person? I don't think they said that. They have not denied that they left him behind.
Yes, they are not denying.
Because they said that I cannot say because he was not dead when I left him.
That is there, Your Lordship. But leaving him there, Your Lordship.
Leaving him there,
Yes, that's
that they have not denied.
And subsequent marriage with the accused person, that is also a conduct, madam.
No, but then you see, that is neither here nor there. They married what, after 2 years after the incident. So in the meantime, they fell in love, could be. We do not know. Where is the proof? Where is the evidence that they were in love earlier?
Nothing is,
Then
nothing is. And one judgment of Honorable Supreme Court, my lord, special repetition criminal number 9221 of 2018. I'll give the citations
for what?
for last seen.
Earlier one also was last week, this also last.
Yes. Para 6/9. 6, 7, and 9, my lord. And about the defective investigation. 2004, Lordship as regards defective investigation.
2004,
3 SCC 654.
6-5. Yes.
Harnas Singh, Elias Shera, and others of state of Punjab. Para 5. In the case of defective investigation, the court has to be circumspect in evaluating the evidence, but it would not be right in acquitting an accused person solely on account of the defect. To do so would tantamount to playing into the hands of the investigating officer if the investigation is designedly defective. So, Your Lordship. Yes, I am giving.
Madam, may I submit some judgment?
Yes.
My lord, for the appellant Hafizur Rahman, my lord, I submit some of the judgment, my lord, regarding last seen theory and leading to discovery, my lord. One judgment, my lord, AIR 2017, my lord, SC 2617, Anjan Kumar Sharma
No,
versus
for last seen theory, which one?
AIR 2017,
AR 2017,
SC 2617,
2617.
Anjan Kumar Sharma versus
Para?
Para 18 and 21, my lord.
18 and 21.
My lord. And another, my lord. 2014 4
For what?
SCC
On the same issue.
last seen, my lord.
2014,
2014 4 SCC
4 SCC,
715, my lord.
715.
Para 12, my lord. Then, my lord, 2020 regarding, my lord, leading to discovery, section 27. My lord, 2020
Just a minute. 2020,
5 GLT
5 GLT
122,
122.
my lord.
Then
And another one, my lord. 2020, 2 GLT 431.
paras,
Uh, in 431, my lord,
yes,
there are 20, 25, and 35, my lord.
20,
25,
25 and 35.
my lord.
And the other one,
And other one, my lord, 19 and 20, 22, my lord. I'm submitting this as well.
okay, right. Heard Miss B.D. Sharma,
My lord.
legal aid counsel for the appellant in criminal appeal bracket J 81/2022. And Mr. G. Sahu,
My lord, DJ Hello,
Mr. DJ Halloy,
my lord, my lord.
then counsel for the appellant in criminal appeal 36/2022. Miss B. Buyan, additional PP appears for the state. Assisted by Mr.
Jadas.
Jadas. 2017. The two appeals. The two appellants have both been convicted have both been convicted by judgment dated judgment in order, same date. By judgment in order.
My lord.
By judgment in order dated 12/1/2022. Passed by the Court of the Additional Sessions Judge, Bijini, BIJNI. In Sessions Case number 329, bracket A, capital A, /2018. Under section
Please go to 34.
under section 302/34 IPC and sentenced to undergo imprisonment for life with a fine of rupees 10,000 each, in default, to undergo simple imprisonment for 1 month. The prosecution case in brief is that FIR dated 17/9/2016 was submitted by the informant bracket PW-1. Right? No? To the effect that on 16/9/2016, when he returned home from Tulsi Jora Bazaar, page 4, at around 8:30 p.m., he learned that at around 4:30 p.m., his grandson, that is the accused, that is the appellant, in criminal A 36/2022, had come to his house along with the appellant in criminal A J 81/2022, along with the husband of the appellant in criminal AJ 81/2020. For better understanding, for easier disposal of this appeal, the appellant in criminal A 36/2022 shall be referred as X, and the appellant in criminal A bracket J close /81/2022 shall be referred to as Y. Thereafter, the DFIR further states that taking advantage of his absence at home, the appellants killed Akhtar Hussain who is the husband of Y, by strangulating him with a rope on the bed inside his house at about 6 p.m. Pursuant to the FIR dated 17/9/2016, which was submitted to the officer in charge of Amguri Police Station, Chirang District, BTAD, what is the police station case number? Amguri PS case number
59.
Case number 59/2016, and the section 302/34 IPC was registered. After investigation was completed by the IO, by the investigating officer, bracket IO, the charge sheet was filed, as the IO had found a prima facie case against the appellants under section 302/34 IPC. Next para. charge under section 302/34 IPC was framed against the appellants on 10/4/2019, to which the appellants pleaded not guilty and claimed to be tried. Next paragraph. The learned trial court thereafter examined 7 prosecution witnesses, and after examining the appellants under section 313 CRPC, came to a finding that the appellants had strangulated the deceased. Correct? With a jute rope. The learned trial court thereafter convicted the appellants under section 302/34 IPC and imposed the sentence as referred to in the earlier paragraph. The learned legal aid counsel for Y submits that there were no eyewitnesses to the crime. She also submits that the jute rope which had been seized by the police and which had been purportedly used for the purpose of strangulating the deceased had not been sent to the FSL for examining whether the same contained the fingerprints of the appellants. Anything else, madam? What else have you got to say? Only that, no?
No,
She also submits in the alternative that no, that's not next. Next, the learned counsel for YX, on the other hand, no, the learned counsel for X submits that the conviction of the appellants was based on the evidence of PW2, PW6 and PW6 by the learned trial.
there is no corroboration, Lordship, for any other witness.
Just say like this. Just say like this. Better. Just say the learned counsels for the respondent. Just say, don't say one. Just say the learned counsels for the respondents submit that there were no eyewitnesses to the crime and that the jute rope which had been allegedly used for the purpose of strangulating the deceased was not sent to the FSL for examining whether the same contained the fingerprints of the appellants. They also submit that the conviction of the appellants had been based on the evidence of PW2 and 6, who are both husband and wives, who are husband and wife. They submit that the learned trial court had come to a finding that the appellants were guilty of murder
having illicit relation without any proof, my lord.
Huh?
They are not having any illicit relation. It is out proof, my lord.
Madam, I'm thinking. I know. I've recorded what has been said. What have I said?
They submitted the relevant trial court had come to a finding that the appellants were guilty of murder.
Murder. On the assumption that X and Y might have been having an illicit affair at the time of the alleged occurrence of the incident, as they had both married after the death of the deceased. So they submit that there is no evidence recorded before the learned trial court with regard to X and Y ever having an illicit affair during the time of occurrence of the incident. Next para. The learned counsels for the appellant submit that the learned trial court had also convicted them on the basis of the last seen theory, which is totally belied by the evidence adduced by the witnesses. They submit that the evidence of they submit that just a minute. They submit that the last seen theory would not be applicable to the appellant, as the last person to have seen the deceased was PW6. Was PW6. That's all. PW6. They also submit that the evidence of PW1, PW2, and PW6 shows that there is discrepancy with regard to the exact time when the deceased was found dead. They submit that in the cross-examination of PW1, he has stated that. No, they submitted in the examination of PW1. PW1 has stated that he returned to his house at 7 p.m. and that the time mentioned in the FIR was not correct. Full stop. In the FIR, the time mentioned was the time of the incident was mentioned as 6 p.m. and PW1 in the FIR had stated that he returned home at around 8:30 p.m. They also submit that PW2 in her evidence had stated that around 6:30, on getting information that the appellants had left the house of the informant, had left the house of PW1 without the man who they had brought into the house of PW1 who could not talk. PW2 had immediately gone to the house of PW1 and found that his tongue was out of his mouth and blood was oozing from his tongue. We also found that the we also found no pulse on the said person, and that the man's leg, the deceased man's leg had become black and cold. However, PW6 in her evidence has stated that the PW6 in her cross-examination has implied that the incident took place around 7 p.m. Correct? Is it correct? PW6 impliedly is implied around 7 p.m. Full stop. The learned causes for the appearance that submits that due to the different time given by the witnesses with regard to when the incident took place, it is not clear as to when the death of the deceased had taken place. Next paragraph. The learned causes for the appearance also submit that X had no time. X is Hafizur, na? X had no time to be alone X and Y had no time to be alone with the deceased to commit the crime, to strangulate him, given the fact that the witnesses all seem to be in and around the place of occurrence all through the evening. Correct? Pusta. The learned counsels for the appellants also submit that the recovery of the jute rope, which had allegedly been used for strangling the deceased, is different as as stated by different prosecution witnesses. They submit that while PW7 had stated that PW7 bracket IO had stated that the jute rope was lying in the corner of the room, comma. The Caesar witness PW1 had stated in his cross-examination that the jute rope was found on one bed inside his house. On the other hand, Caesar witness PW5 had stated that the jute rope was lying near the bed where the dead body was lying. They submit that in view of the discrepancy in the place of recovery of the jute rope, it can be said that the jute rope was not recovered on the basis of any statement made by the appellants. They also submit, next para, the causes for the appellants also submit that while the evidence of the doctor PW4 is to the effect that the dead body had been identified by UBC 232 Ainal Haq, AINALHOQUE, and Hussein Ali. The two persons were not examined by the learned trial as they were not made prosecution witnesses. So what is the effect of that? But so how does it help you? So you mean to say that the person dead body is not so and so? He accordingly submits what? That the deceased dead body was not so and so. Is that your case?
No, my lord, my submission is that my lord, that these two persons that they are the persons to identify the body matter. It is the duty of the prosecution to examine or list it as a prosecution case matter. My lord, as these two persons, my lord, they identified the body, my lord. There is no other family members, my lord.
So how does it matter? Is it your case that somebody else, not the person who died in the house of PW1? Is it your case?
So, my submission before the lordship, my lord, that the PW2, he has stated the tongue was outside.
How does, no, just tell me one thing. Just tell me one thing. Is it your case
No,
that the person who died is not the person who died in the house of PW1? No, then how does it matter? It has got no relevance. That last portion you cut, no point. There's no point. I can record, but then it has no. But if you're going to make some submission out of that fact, then I understand. But what is your submission? I don't know. How it will help your case also, I don't know. There's nothing. Cut that. Okay, next. The learned causes for the appellants thus submit that the learned trial court could not have based its findings of guilt upon the appellants on presumptions, as the same has to be based on facts. They submit that in support of the submission that the last seen theory could not be a basis for convicting the appellants, they have relied upon the judgments of the apex court in AIR dash versus dash, reported in AIR 2017 SC 2617 and 2014 4 SCC 715. In support of the submission that the Rakesh, you call one data or someone, huh? In support of the submission that that there was no disclosure. In support of the submission, no. Is there? Where were you hiding? In support of their submission that the recovery of the alleged jute rope used for strangulating the deceased was not based upon any disclosure statement made by the appellants, they have relied upon the judgments of this court in division bench judgments of this court in the case of Abdul Malik bracket MD versus State of Assam and another. Okay. Reported in 2025 GLT 122 and Akibul Ali bracket MD versus State of Assam and another, reported in 2020 bracket 2 GLT 431.
No, my lord, this is the second statement.
Second set. The learned counsels for the appellants thus submit that the impugned judgment and order should be set aside and the appellants should be acquitted of the charges framed against them. Correct? Next, the additional PP on the other hand, submits that the informant bracket PW1 is the grandfather of X. PW2 is the grandmother? No.
Three.
Three.
Three is the.
For some, also PW3 is the grandmother. No, not grandmother actually.
Grandmother.
Again, grandmother.
Grandmother.
No, the second wife. Oh.
Still in grandmother only.
Not real
Grandmother's
grandmother,
wife.
step grandmother. Step grandmother. No. She submits that the evidence of PW1, PW1, PW2, and PW6 clearly prove the guilt of the appellants, as they were last seen with the deceased, and they could have been the only ones who could have strangulated the deceased. She also submits that. No, the additional PP also submits that. There is no denial by the appellants that they were with the deceased in the house of PW1. As such, due to the close proximity between the time of their arrival in the house of PW1, the time of their leaving the said place, and the time of discovery of the death of the deceased, the circumstantial evidence clearly pointed to the crime having been committed by the appellants. In support of a submission that the close proximity of the place and time between the event of the appellants having been last seen with the deceased and the factum of death, the only conclusion that can be reached was that the appellants had committed the crime. She has relied upon the judgment of the apex court in Amit alias Ammu, AMMU versus State of Maharashtra, reported in 2003, 8 SCC 93. Why is this 2004-3? How is it relevant to this
It's
fact?
like in the investigation.
How is it relevant to this case?
It's not fatal to the prosecution case. They say that there's lacuna, material cases were not examined, the, that, rope was not sent for FSL and all. That's not fatal now.
How does this have any effect? In support of a submission that it would not be right in acquitting an accused person solely on account of defect in the investigation, she has relied upon the judgment of the apex court in Dhanaj Singh alias Shera and others versus State of Punjab, reported in 2004, 3 SCC 654. Yes, sir. In support of a submission that the last seen theory was established by the prosecution can be used for convicting an accused, she has relied upon the judgment of the apex court in Ram Gopal, son of Mansharam, versus State of Madhya Pradesh, special leave petition criminal number 9221 of 2018. That's all.
Leading to discovery.
Huh?
It was leading to discovery and the conduct of the accused person. Those two.
Leading to discovery we have also already mentioned. No?
Because the accused
Okay,
person
first
happy
up,
to
she also
accuse
submits
acts made by
that in view of the disclosure made by whom?
the accused person.
Which, both of them?
No, X.
In view of the disclosure statement made by X, the recovery of the jute rope had been made by the police, which had been used for strangulating the deceased.
Conduct.
Huh?
Conduct, my lord.
First of further, the conduct of X,
More particularly the Y.
conduct of X and Y, as per the evidence given by the prosecution witnesses, especially PW2, would go to show that the appellants were aware that the crime had been committed by them. So she accordingly submits that as there is no grounds to interfere with the judgment and order of the learned trial court, the same should be upheld. We have heard the learned counsels for the parties. Okay. Then you say, so, heard, hearing concluded, judgment reserved. My sister got a single bench to attend to. That's why we have to stop at this stage. Oh, yesterday's matter, you just right. They're not here. Anyway, my sister got a single bench, so we cannot do it. We'll list it next week. Maybe Wednesday. Oh, huh? Due to paucity of time, list the matter. Let's say in the next week. List the matter in the next week, whenever they can be. Acha, one thing. Should we remove this glass? They cannot hear properly. It'll be difficult. That's it.
He's here.
Yes, you see, we could not even finish dictation of this case.
Yes, that I understand.
Because first of all, no time. Secondly, my sister has got a single bench matters to attend to.
Yes, my lord.
So she has got to go there.
No,
That's
my
it.
lord, I completely understand.
So
But can we
next,
do one thing, my lord? Can this matter be fixed on Monday? And tomorrow, on the Monday morning, I will make a mention and let this matter be taken up as a first item of hearing. And that be done.
Monday we have already
Monday
fixed
this
some
has come up.
items.
You,
This is come
And
out.
this has already come out.
then my lord, on 17th, because on 15 I'll be out of station. That is why.
Oh. 17th we have got to
Friday.
change Chaudhary
Friday.
and that he does change Chaudhary that.
Provided the bench is comfortable with. And
We've got some senior advocates coming there, see some writ petition matters
on Friday.
on
my lord,
17th.
On
yeah.
17th,
The medical admission.
Medical admission matters.
medical application.
So
Then my lord, may kindly fix the matter as per the convenience of.
it's we have done some already so much hearing we have done. 17th, 16th, you're not here.
My lord, 16th, I shall try to be here.
If possible, okay. List
Then
the
the
matter.
week thereafter.
If it's possible, otherwise we'll adjourn it, no problem.
Deeply of that. Deeply of that.
16th, huh?
16th. Let it be on 16th.
If
And I
possible.
also tried my level best to be present.
No, it's okay. I think also. But we'll try, everyone will try.
Deeply of that.